Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Thanks so much for going to join me today. Today is, what's today? Today's Wednesday, April 16th, 2025. And we have a jury. We have a jury. For those of you who were with me yesterday, the jury was seated while we were live for 3 hours doing other things and going through other filings on the Karen Reed case. And we have another jury, 9 women and 9 men. 18 jurors have been seated. 6 will be chosen as alternates at the end of the case, and 12 will sit on the deliberating jury. And it's very exciting. And although it's not going to start until next Tuesday, today we have our final motions hearing, and who knows what's going to happen today. Could be crazy, could be short, could be all day. You never know what's going to happen. But what we do know is that we already have one filing this morning, and that's a motion to add Victoria George as local counsel for the Pro Hoc Vice attorneys. Victoria George, some of you may remember, sat as a juror on during Karen Reed's first persecution. She was chosen somewhat suspiciously, perhaps, as an alternate right before deliberations, and she is so outraged about the injustice that is being blatantly happening in the Norfolk Superior Court with regard to the persecution of Karen Reed that she has become a part of the defense team. And so docket number 671 was filed, I believe, this morning to add Victoria George as additional local counsel for Pro Hoc Vice attorneys. We saw this once before. We saw this when Queen Tanis Yannetti, I call her Queen Tanis because, boy, did she command the courtroom that day. There was one day her brother, David Yannetti, could not be in court. And so Tanis Yannetti served as Pro Hoc Vice attorney for Alan Jackson, I believe, and Elizabeth Little, who were Pro Hoc at the time. And so perhaps David Yannetti can't be there today. Not really sure. But in any event, here's the filing. I'm waiting for the court feed to come up. It's not up yet, so don't worry. We're not missing a thing. It's supposed to start at 10, but I don't know if they've ever started on time in Judge Cannoni's courtroom. Oh, well, we've just been informed that it will be starting at 10:30, so we've got some time. So now we get to go over docket number 671. Docket number 671. Motion to add Victoria George as additional local counsel for Pro Hoc Vice attorneys. Victoria George of the law firm Yannetti Criminal Defense Law Firm and a member in good standing of the Massachusetts Bar, hereby moves to be added as local counsel for Pro Hoc Vice attorneys Alan Jackson, Elizabeth Little, and Robert Alessi. We call him Bobby Scissorhands Alessi because he's going to slice up the Commonwealth experts like no attorney you have ever seen. who have previously been associated in as counsel of record for the defendant in the above captioned matter. In support of this motion, counsel states as follows. 1. The undersigned Victoria B. George is a licensed attorney in good standing in the Commonwealth of Massachusetts. There's her bar number. Is associated with the Atty criminal defense law firm and has served as local counsel for Karen Reed in this matter. On September 22nd, 2022, Judge Krupp granted the motion for admission pro hoc vice of Alan Jackson and Elizabeth Little to represent Karen Reed in this matter, with David Yannetti serving as local counsel. Wow, that was all the way back in September of 2022, before Judge Cannoni even had this case. Oh, those were the days, my friend. Those were the days. I think we liked Judge Krupp. I think we liked Judge Krupp. On November 22nd of 2024, this court granted the motion for admission pro hoc vice of Robert Alessi to represent Karen Reed in this matter, with David Yannetti serving as local counsel. 3. Victoria George is associated with the Yannetti criminal defense law firm, is familiar with this case, and is prepared to serve as additional local counsel for Alan Jackson, Elizabeth Little, and Robert Alessi. David Yannetti will remain primary local counsel for attorneys Jackson, Little, and Alessi. So Victoria George, in case there was any confusion, has been hired by the Yannetti law firm. Number 4, good cause exists to grant this motion because Attorney Jackson, Attorney Little, and Attorney Alessi have specialized skill and knowledge in representing defendants in matters of this nature. Should the court grant this motion, I will act as co-counsel during the pendency of this matter. Counsel has paid the Board of Bar Overseers registration fee of $355 per attorney, as required by SJC Rule 315. Attached here too is Exhibit A are the registration statements for Attorney Jackson, Attorney Little, and Attorney Alessi, respectively, issued by the Board of Bar Overseers. Wherefore, Victoria George respectfully requests that this court permit she be added as local counsel for Alan Jackson, Elizabeth Little, and Robert Alessi, XOXO, Victoria Brophy George, Esquire, April 16th, 2025. Okay, so there's that. I don't know if that means David Yannetti's not going to be there today. She has no reason to not grant this, but no, she did not work for David when she was on the jury. She was just hired by David Yannetti, I think, after she gave a Vanity Fair interview, which would have been within the past few weeks. I think the day that they filed her notice of appearance was maybe even the same day she was hired. So no cat. Nope. Hopefully that clears up the clarification. Team Brittany. Hi, Team Brittany. Good morning. I put in the chat, I dropped it in the chat, the link to the merch shop because it's 20% off today. I just can't get back that far to find it, to pin it. So if you see it, could you pin it for me, sweetheart? Thank you. Because every time I tried to get my fingers on my phone, it just took me to the link and it didn't work unless I could find it. So it's 20% off today for the next, I think, 2 days. We did a big giveaway yesterday. We had 4 giveaways. I think there was one winner who did not reach out to me. I think I'll go through my emails and see. But if you did reach out to me and sent me your information, I will send you your choice of merch. Just don't forget the thumbs up for those of you who are just joining. We've been advised court's not starting until 10:30, so we have a minute or two to talk amongst ourselves. Good morning, Mark and Cindy. I've been members for 8 months. Thanks, Mark and Cindy Hoskins. On top is here, on top of the super stickers, as always. Good morning, Random Thoughts says, let's go. I have my bubble wrap ready. Oh, does that help you in times of stress? The bubble wrap? That's a good idea. Thank you, Random Thoughts, for your super chat. Altman's here. Looking forward to watching Trial 2 with you and your family here. Yeah, we have a lot of fun here. Thank you. Thank you, Ms. Altman, for your super chat. Christy, a painter's daughter, has been here for a year. She said it's been a year. What are we still doing here? I wish I knew. We also have a Karen Reed playlist on Spotify that is in the show notes below this video. We had some new additions to the list yesterday. And one song that's one of you viewers, one of you amazing Snark Tank viewers turned me onto that I was not familiar with, that I love now. I put it on my Instagram story. It is a song by a guy named, where is it? Avi Kaplan, AVI Kaplan. It's called Change on the Rise. And I love it. Thank you for whoever pointed me in the direction of Avi Kaplan. I think he was with Pentatonics for a long time, right? Christy, I don't know what we're still doing here, but we're here and we're together. So that's all that matters. Fairy Raven Emma is here from Ireland. Thank you for being here with us, for Melanie. For 14 months, you're an OG, Emma. OG. Slancha, my friend. Slancha. Superstar Karen has been here for 3 months. Love all you, Amelia, the best. Love you. Hope you explain everything. That is, hope you explain everything. God is that don't get it. Yeah, whatever you need, babe. I'm here for you. I'm here for you. Mama She is here. It was her birthday. The happy birthday again, Mama She. Very kind and generous contributor to the channel. Cupcake family is the best. And the Goodwins are here, and they gifted a membership, and they've got their logo there is I went to Cancun with attorney Melanie Little, which if you know, if you're an OG, you know the the lore behind that story. There was a rumor going around on Twitter that I went to Cancun with Alan Jackson, and it was ridiculous. And there was a self-appointed reporter who you may know, but we don't really talk about him on this channel, who ran up to Alan Jackson on the courthouse steps, like during the first trial, at the beginning of the first trial, and said, and he had, mind you, has one of the most amazing trial lawyers in the country in front of him, and he chooses to say to him, oh, did you have fun in Cancun with Melanie Little? And then shoves his phone in his face as a microphone, and it was ridiculous, but we made merch out of it. Thank you, Goodwins, for gifting a membership. Here's your mom. Becky's mom and Becky are watching from Northern Ireland, and she's been here for 10 months. Thank you so much. Tracy Fagan says, is Holly Price on the witness list? Yes. Keeper of records for Google? Yes, she is, Tracy. Thank you so very much, Mrs. Bouquet. Thank you for your super sticker for tuning in from across the pond. Hans Solo Cups is here, formerly known as Midnight Mike, and he's gifting 5 memberships, and he's amazing. So welcome to the 5 new viewers. I want to show you this cool video. Somebody tagged me in it, and then he also reached out to me on Instagram. For those of you who try and send me Instagram messages, the format of Instagram is such that the messages on Instagram get sent into some deep, dark black hole that I have no idea how to access. And they just don't ever show up. So I apologize to you if you've sent me messages on Instagram. It is not the way to reach me. If you need to send me something, my email is in the show notes. However, understand that I get 700 emails a day. I do read them all. I cannot respond to them all. However, Derek Carney is his name. He wrote and made this cool AI video with a theme for Karen Reed, a theme song. And he said that I could play it. So I'm going to play it for you because I thought it was pretty cool. And I think you're going to like it. And the song might get stuck in your head. But what I like about this is that the AI in this video is wicked cool. So let's play this as a little entertainment while we wait for court to start. And it's called How Dare You, the Karen Reed anthem. He would like it if all you boots on the ground out there were singing this song for and in honor of Karen. And yes, the opening frame is a little frightening. It may give you PTSD, but just listen. Here we go. I will link this in the show notes so you can go give him a like on his channel. Derek Carney. I think he's only got something like 80 subscribers, so give him a like because I think you're gonna like this.
Won't find a fingerprint, how dare you? How dare you? Won't find one drop of spit, how dare you? How dare you? There's no evidence here, how dare you? How dare you? But the truth falls on a deaf ear. I'm innocent, how dare you? Magnificent, how dare you? Your accusations are not based in reality, and I deserve much better than you're treating me. When you die, you will see what a monster you've been to me. Is my love not enough? Can't you just be happy in this love? Why you gotta make it so rough when we've been blessed with this gift from above? Won't find a friend. How dare you? How dare you? How dare you?
So crazy, right?
You won't find one drop of spit. How dare you? How dare you? There's no evidence here. How dare you? How dare you? But the truth falls on a deaf ear. I'm innocent. How dare you? Magnificent. How dare you? You my one. You're my 1, 2. You're my 1, 2, 3. I love you. I need you. Just believe in me. I'm innocent. How dare you? Magnificent. How dare you? How dare you? How dare you?
I know, this is great. Selfie with Judge Kim Jong Kanone.
Is my love not enough? Can't you just be happy in this love? Why you gotta make it so rough?
Shout out to
Blessed with this gift from above.
favorite artist.
How dare you? How dare you? How dare you? How dare you? Won't find one drop of spit. How dare you? How dare you? There's no evidence here. How dare you? How dare you? But the truth falls on a deaf ear. I'm innocent. I'm innocent. How dare you? Magnificent. How dare you? Stop this judgment. How dare you?
How dare you?
How dare you? You're my 1. You're my 1, 2. You're my 1, 2, 3. I love you. I need you. Just believe in me. I'm innocent. How dare you? Magnificent. How dare you? Stop this judgment. How dare you? I'm heaven sent. How dare you? How dare you?
I dropped the link in the chat so you can just click on it and give them a sub and a like.
How dare you? I'm innocent. How dare you? Magnificent. How dare you? Get yourself right, 'cause I absolutely don't deserve this. And I've put up with it for way too long. Better wise up, straight up. Get it together, wise up.
Yeah, isn't that awesome? We love that. We love to shout out new artists. Oh, well, we're going to get dinged for that one note of a Dave Matthews song, but I dropped it in the chat. This is a video by, his name is Derek Carney. I think I'll put it in the video description now so that you can check it out later and you can sub up to him. The fan is still up in the, isn't that awesome? His name is Derek, D-E-R-E-K, Carney. Let me just put that in the, I have less than one brain today, but we are in the land of the lost, and we have a new mascot. I'm going to show you that in a minute. My Gen X cronies are going to know this this mascot. It may give you a little creepy, another creepy blast of the past. It is wild how AI is so disturbing in so many ways. It's putting so many actors out of work, and it's you can see the danger of it, right? The deep fakes. And this is why metadata is so important. And I saw that fly by in a super chat, which I'm going to address in a second. But yes, as you can see, metadata is so important because look how easy it is to manipulate a video. I mean, that looked wicked real to me. How about you? Did it look wicked real to you too? All right, I'm going to drop that in the description right now so that you can. Derek Carney video. So that you can sing along to the theme song, How Dare You, for Karen Reed. It's so cool, right? So cool. Irony in the land of the lost is here. Oh, thank you for letting me segue into that nicely. We are in the land of the lost, upside down of Narnia, and that reminded me of the television show from the 70s. And so our new mascot, some of you may remember, this guy or girl, I don't know if it's a guy or a girl, but if you can name that character from Land of the Lost, but only if you weren't here yesterday. It's Shaka time. This is what we all feel like when we're watching this trial. We feel like Shaka. This was an episode called Possessed, and I think Shaka was possessed during this. But so many of you have probably had nightmares about it since I put this up on the screen yesterday. Yikes! Shaka is possessed. Irony in the land of the lost. What? See, you guys are so amazing. The way you change your screen names to match every single thing we're talking about. I love it. KOB, thanks for your 5. Says, let's go, free Karen Reed. Thanks for your amazing coverage of the circus. Listen, we got to laugh or we're going to cry. We try and throw in a little comedy, a little music, the kind of music at least that we can't get stricken on. Mama She says, thank you, Mel. And best birthday gift was your collab with Larry. Oh, let me tell you something, Mama She. And those of you who did not watch my collab with Larry, the DUI guy, I have a community post about it. It's on his channel. We taped it. He's got an amazing editor. And I have never, on any video that I've ever done with anyone or even alone, received more kind comments than were on that video. People loved it. We had a great banter. He's got a great editor. And if you haven't seen that collab that I did with Larry, the DUI guy, check it out because it was only about 47 minutes. And when I say only about 47 minutes, is because usually my streams go 3, 4, 5 hours because we have so much to talk about. But thank you for liking it. So many people liked it. Teresa Nick, thank you so much for your super sticker. And Tazo has been here for 7 months. Says, I appreciate you as I recover from bunion surgery. Well, we're here for you and your feet. And hoping that you are feeling better soon. And we appreciate you even more than you know. Random Thought says, this is wonderful. Yet at the same time, it scares me. Well, yeah, it is scary. I put the link in the video, in the show notes underneath the video. If you want to watch it again and go give Derek a like and tell him I sent you. Because he did, like he sent me a message on Instagram. It got lost in a black hole. And so there it is. He said, please play it on your channel. I said, absolutely. I love it. And Hello Kitty says with a super chat, this video shows why metadata is so important. Look how video can be manipulated. Awesome video and song. Yeah, shout out to Derek. And shout out also that he showed the art of Don Ciccio. For those of you who don't know Don Ciccio, I'm going to introduce you to Don Ciccio. This is another creator that I found. He's not a YouTube creator, but he's an artist that I stumbled upon one day, or someone maybe sent it to me. Sent me his artwork on Twitter. And hang on a second. And he's an artist, and he sketched everybody in the Karen Reed trial. Why can't I find it right now? And so he did like these watercolors of all the characters in the Karen Reed trial. And I shouted him out. And I think at the time he had something like only 181 followers on Twitter, or whatever you call them on Twitter, subs or whatever. And now I think he's up to like over 2,500. And so I'll show you some of his artwork so that you too can go follow Don Ciccio. And then I said I would love it. It would be so cool if he made a watercolor of me. And he did. Because Don Ciccio, his name is Chris. He's an amazing artist. And it's good to share other people's talent, help other creators. I came across another video last night. Maybe if we have some halftime here, or some a break at some point, I'll show you her video. Her name, I can't remember off the top of my head right now. Ugh. I'm looking through all my saved stuff, and their Big Case Mike's face just came up, and it gives me the heebie-jeebies. Remember Big Case Mike? I hate Karen Reed. I hate that woman. I hate that woman. Why can't I find Don Ciccio? Am I spelling it wrong? I'll come to it. It'll come to me. Oh, there was also another day that we were talking about that weird piece of playground equipment, which I did find, and I still don't know what it's called. How is everyone today? Here he is. Oh, Don Ciccio 74. Okay, let's go here. Because this fan makes me nauseous. Canoni's Baloney says, I found it on YouTube Music and added it to the favorites. Oh, yay, Jazia. Yay. Joseph is here. Say hello to my sister, Mary Jo. Hi, Mary Jo. And hi, Joseph Sands. Thanks for coming. Thanks for coming. It's going to be a good day. It's going to be a good day, I think. And Manj is here. Morning. That video is awesome. What are the odds they go over the jury form before trial? I'm being a wise ass, or do they have to wait until the end with jury form? What do you mean? The jury instructions? No, they don't. She gives them some instructions when they first sit, when they're sworn. That won't happen until next week. She does give them a couple of instructions, but the major jury instructions about reasonable doubt, etc., those come right before closings. Okay. Thank you. Thank you for asking. Kissangura, thank you for your 10. Have you watched the reconstruction of the timeline by Microdots on YouTube? It's called The Drop Off, and it includes the times of Gemma Cave's calls. Is chilling. Is it new? I watch every single thing that Richie Microdots does. And so if it is super new, like from yesterday, I probably haven't watched it yet. But shout out to Microdots because he does amazing, amazing work. And he's a fearless creator and a leader in the free Karen Read debacle that we find ourselves caught up in. BG is here. Thank you so much for your super sticker. It seems here that, this is interesting. So Aiden Carney, after 2 weeks of bugging and asking him, clerk Jim McDermott alerted my attorney via email at 9:45 this morning that he needs me there by 11 to hear our motion to exempt me from the sequestration order. We went over the papers on that one yesterday. I live an hour away, so I had to get ready, and I just left. Should be there by 11:15. Really? Really, Jim? You've got one job. One job you've got. One job, and that's to make sure that everybody's there. And no, you couldn't do it, Jim, could you? Couldn't do it, because let's just do everything ex parte like they did last time, right? Or they tried to do anyway. So let's show you Don Cicchio's Twitter feed. So when we first looked at Don Ciccio, he had, 181 followers, and you guys all went and followed him. Most of my audience is not on Twitter, but some of you are. And for those of you who are, check it out. His name is Chris. He goes by @Don Ciccio. Let me make him bigger. Hold on. @Don Ciccio 74. He's an artist and a musician. And an amazing artist, because check this out. This is his rendering as such of Jen McCabe. And there's another one that might give you PTSD as well. You guys are following Chris? Good. This is the Barros, the Dighton cop. I think some of these are sketches and some are Detective Lieutenant I Wear Shorts All Winter Tully. Oh, he's going to be an interesting cross this time, isn't he? Who knows who that is? Katie McLaughlin. She went to high school with someone named Caitlin Albert. There's Tristan. I don't know what time it is, Morris, but he did approach Dave Portnoy about doing a collab with him for Brick Watches. Said he was going to be a witness in the Karen Read trial, allegedly. I think that was him. It was either him or one of the other guys. Hang on. I think it's been confirmed that it was Kristen Morris who went to him at something called IceCon, which is like a hockey thing, and said, hey, you want to give me a brick watch? I'm going to be testifying in the Karen Read case. And, I'll wear the watch on the stand. And wouldn't that be perfect, though? I mean, it is kind of genius because Tristan Morris did not know the time that anything happened. So for him to, yeah, and Chris Carrera says I wouldn't rule out Ryan Nagel. But wouldn't it be such poetic justice if it was Tristan? Because remember his testimony, he didn't know the time of anything. And if he does show up wearing a brick watch, which is apparently Dave Portnoy's watch company, they're not cheap. They're a couple $1,000s. It would be wild, right? Time's up. And look who, if anyone was driving the ambulance, and look, he gave Lally the baby shark hairdo. I started calling him Baby Shark during the trial because I have 5 kids, and when my kids were babies in the bubble bath, they used to make a little shark fin on their head with the bubble bath, And so we started calling him the Baby Shark hairdo. I'm wondering what product he uses and whether he'll have the Baby Shark hairdo today. Aiden said it was Tristan. It was confirmed. That would be the definition of poetic justice. Aiden said it was Tristan, huh? The irony of Tristan endorsing a watch. I hope it's digital. Leslie's binder is better than Breenan's binder. We've been notified court's not starting till 10:30 at the earliest, so the fan is still up. We're not missing a thing. Don't worry. Don't worry. We already went over a motion filed this morning to have Victoria George able to sponsor the Pro Hoc Vice attorneys because maybe David Yannetti can't be there today. I'm not quite sure. So we're looking at some artwork, and we watched a really cool AI video with a theme song for Karen. And there's one of my favorites anyway, Brian Lucky Lochran. And God forbid any animals is the way Chris captioned this one. Oof. Oof, Maron. And then he also has some political. Oh, look, he did another Jerry Garcia for me because that's how I found him. I loved the Jerry Garcia, and then I said, "Wait a minute, he's doing the Karen Reed trial sketches. That's amazing." And he's not in the courtroom. He does this from home. I don't know if this is a side gig, but he has some amazing artwork. He does a lot of political figures, a lot of rock stars. This is Mr. O'Keefe. The sadness is palpable. Nathan Reed. Pretty cool, huh? Pretty. Oh, and there's Vinnie Politan. Oh, with some other people that I'm not really fans of. Ricky D'Antuono. So check it out. There's Heather Maxson. She was sleeping in the back seat. She didn't see much. And you know who that is? Colin. Allie. Oh, the Alessi ones are great. Look at these. These are watercolors, I think. Oh, the fan is still up. It's still making me nauseous. Little, no relation. Alan Jackson. The Rage Crochet Club is in session if anybody would like to join. I'm not sure who the president is nowadays, but we do have a Rage Crochet Club here. King David Yannetti. Higgy the beta male. Mr. Proctor. Let's see where mine is in the feed. He did me. He made me look like 30 years younger, but I'll allow it. Hang on. I will allow it. There it is. And he gave me a shout out and said, "Thank you, Melanie Little." And how sweet is he? How sweet is he? Yes. Turtle Boy's motion is being heard today. Thanks, Lauren. We just, we were waiting. Apparently he was just called. His attorney was just called at 9:45 and said they got to be there by 11. And he lives an hour away, he says. So it's going to take him a while to get there. That is just one of the motions that is being heard today. So go give at Don Ciccio 74 a follow on Twitter because he's awesome. He deserves it. And let's get him to let's break 3,000. Let's let him break 3,000 followers. Maybe the audio will be better in court today, but I don't know. I don't know. Oh, let me change the captions. People were complaining that I had the captions in pink lettering. So hang on. But you know, I'm not a cupcake. I can't make everyone happy. However, if it's really hard to read, I guess I have to change the color. I did like it as pink, but you know, hang on. Font, color. See, you can do this on your own end. I guess we're going to go back to white. That's yellow. It's green. What's the easiest to read for those of you who need them? White on black. All right, we're going back to white on black. And the fan. On top says Beta Higgy will be moved into evidence. We'll see. We will see. Thank you, BG, for your super sticker. Bohica, wait, what? Says, good day. I'm wondering if the defense can request clarification when the persecution objects with no explanation behind it. No. Not in this courtroom. I come from a land known as New York, where in court, if you stand up to object and you don't state your reason for your objection or your grounds for your objection, The judge will stare you down until you do. Here in Massachusetts, apparently it's not a thing. And this judge does not allow grounds to be stated in court. They have to go sidebar, or else she'll just rule on a whim and guess. And so thank you for thanking me and for your $10 super chat, but nope. They can't request clarification. They're just supposed to know. And that way, I guess in Massachusetts, all grounds for objections are preserved for appeal. I guess that's the reasoning behind it. I don't really know. Like I said, we're in the land of the lost. Our mascot is Shaka. AJ from Shy says, I might have missed it, but is the trial actually starting today? No, today is the final motions hearing. Openings will happen next Tuesday. I don't know what date that is. Is it the 22nd? Because Monday is a court holiday in Massachusetts. It's Patriots Day. It's the day of the Boston Marathon, and their courts are closed. And so it will happen on Tuesday, April 22nd. There will be no court. I don't think there'll be court tomorrow and Friday. I don't know. Is this a rumor that I just dreamt? Did somebody say that the crash daddies are in the building? That maybe they're doing their voir dire today? I don't know. I don't want to start a rumor, but I thought I saw it either in passing or in the chat or somewhere. I don't really know. So no, the answer is no, not today. Thanks, Sonia, for becoming a member. Thank you, Karen Lisk. Jim is Bev's grunt. He had 3 DUIs. Well, I don't want to talk about his personal problems, but there was somebody on Twitter who posted that, like an old newspaper clipping, that apparently that clerk, Jim, was in a major car accident with this person's mother and destroyed her life. Like the damages, like the injuries to this woman were devastating, and she died a couple of years after. And the person said he ruined her life. There's no jury today. Today's just going to be a motions hearing. Apparently, Aiden Carney is told he needs to get there, but he wasn't notified until 9:45 to be there at 11. So on top says Beta Higgy will be moved into evidence. Yeah, maybe. Yeah, I don't know if the crash daddies are there. Does anybody know? We have a rage knitting club as well, apparently. Yeah, Aiden was home when he got the email. Right. He wasn't notified. So I don't know if that's true or if I just dreamt it, that the crash daddies were coming in today. I don't know. I don't know. It's crazy. It's crazy. LJ says, because why would an objection need clarification for Bev? It's subjective to her decision, right? Or, listen, the entire first trial, we heard her saying, Mr. Lally, do you want to object? Mr. Lally, do you want to object? And then when we rewatched some old testimony recently, you can see, like when Colin and Allie are on the stand, they would be asked a question that they didn't want to answer, and they would look at the judge. Allie looked at the judge a couple of times as if the judge was going to save her. And then she just looked at Lally, and then it would be like, Mr. Lally, do you want to object? And it was like mommy helping him from the bench. That too, LJ, is what I think. So all my opinions, these are all my opinions, and I'm entitled to them, right? Sonia says she had to resub because she lost her card. It happens. Also, what happens, and I've noticed this on my own subscriptions. I'm like, oh, so-and-so hasn't done a video in so long. And then I go and I realize that somehow it moved me from all notifications to, just personalized notifications. So if you haven't seen a video come up from me in your feed in a while, it's because of that. YouTube is glitchy. It does that sometimes. So make sure right now, while we're waiting, we got some time to kill. Make sure that you have your little bell on the bottom there set to all notifications, or you're going to miss something, and you don't want to miss a thing. Because us together collectively are going to be streaming this trial every single day, because we were here the entire first trial. We're going to be here together for the second one. And we're going to have to get some coping skills. Opening arguments. Yeah, this is motions. Opening arguments on Tuesday for just joining. That is correct. Oh, yeah? Kyron says, at the Canton Town meeting last night, a resident called Chris Albert out. That must have been fun. Nico, like Michael Marcy, 2 had a drunk driving episode that was ruled as a medical episode. Oh, well, we don't know. We don't know that. I mean, I don't know that. If it was ruled a medical episode, I can't, I speculate, but I guess that's the word on the street. Thanks, Nico, for your super sticker. But we have to be careful with defamatory language in the chat. So we try and keep it drama free. Drama free. There are other places that you can go for your drama fix. This isn't one of them. Hi, Mimi. Mimi says the only good thing about Trial 2.0 is we have you to help all of us with non-legal brains get through this atrocity of a quote fair trial. Yeah, it is. It is an atrocity. It's an atrocity. We are waiting right now, JD. Hey, JD. You're making remixes. We watched a pretty cool AI video with a new Karen Reed theme at the beginning. If you haven't seen it, check it out. You can rewind. We're waiting for the attorneys to come into court. We've been told it's not starting until 10:30. It's going to be a motions hearing today. The jury is not here. But the jury has been picked. They've been picked. 9 men, 9 women will decide the fate of Karen Reed, who is facing a second-degree murder charge, which carries up to life in prison. Okay? So for those of you who don't understand how serious this is, murder 2 in Massachusetts carries life with the possibility of parole. Murder 1 is life without the possibility of parole. We know that because Dr. Turk, who was tried in this exact same courtroom, but with a different judge who we liked a lot better. Let me put Don Cicchio's name up. I think I have a banner with his Twitter name. Hang on. The judge in the Turk trial was, tell me his name, you guys. My brain is freezing. It wasn't Judge Sisitsky. Oh, Judge Mark Halal, Hallal. And he was in the same exact courtroom. His name is Chris, and that is his Twitter handle, at DonCicchio74, which is a nod to The Godfather. If you know, you know. And you know that I love The Godfather because every time we leave, I say, if I don't see you soon, I'm gonna die. I love you with all of my heart. And that is a scene from Clemenza, from Godfather. It's called the Clemenza's meatball scene. You can look it up. I can't play it because I'm sure that they would not like that. The owners of the Godfather footage. Right. Crime scene tell you anything else? Did the crime scene tell you anything else? Thank you, says I love you with all of my heart. If I don't see you soon, I'm gonna die. Michael, tell the pretty girl you love her. And he's on the phone with who's he on the phone with? It wasn't Apollonia, right? It was I don't remember who he was on the phone with. But anyway, that's what it's from. Thank you so much for your super chat. And also, Haas dare you. Haas dare you has already changed the name. It's kind of gets stuck in your head, right? It's like a brain worm now. Haas dare you. Haas dare you. Oh yeah. So this happened to me this morning. So I wake up, and I'm looking at my notifications on YouTube. And of course, you got to wake up to a nasty comment, like always, right? So shout out to the Mook, who decided that it would be so cool to go on my yesterday's video and comment this. Surprising typos on the thumbnail. Attorneys are usually detail oriented. So I'm like, you know how I feel about misspellings, right? Because I was a spelling bee champion at one time in my younger days. And so I go back and look at the thumbnail and it says Haas long till openings. And so I wrote, oh, tell me you know nothing about this trial without telling me you know nothing about this trial. Who does that? Who gets up in the morning and says, you know what? I think I'm going to go do something nasty and ruin somebody's day. It doesn't ruin my day. I'm just kidding. But it's just ridiculous. Right? Oh, Lee went out to investigate Avi Kaplan. Wow. Just wow. Yeah. Somebody recommended it to me yesterday. I hadn't heard of him before. He was with Pentatonics. He's on the playlist. For those of you who don't know, we have a trial playlist on Spotify. It's in the show notes below. You can listen to it. We have 100 and something songs on it. And I couldn't believe that the 4 Non-Blonde song was not on there. So I apologize to whoever it was that I said, of course we have that on there. We don't. And the name of the song is called What's Up. And I think the reason that I thought it was called What's Going On, because that's the chorus, right? What's going on, right? But no, it is called What's Up. And then I also put Better Things on there by the Kinks, because we were talking about the Kinks yesterday, and I do love the Kinks. And then we put Suspicious Minds on there, which I also thought was on there. But anyway, the Avi Kaplan song is called Change on the Rise, and it's fire. We also had recommendations for The Liars Club by Coheed and Cambria. I put that on there. So that's what we do here. We think in song lyrics, and it's a lot of fun. It's a lot of fun. All right. So there's Don Cicchio's handle. Go follow him on Twitter. He's an amazing artist, and he's a really cool guy, and we've corresponded. And I've been meeting so many cool people, in this YouTube journey. So many cool people. I just put his name up on the screen. So if you didn't see it, yes, okay. You get all the credit. Better Things you did. Can you use different words? You did. You get all the credit. I love that song. You'll find better things. It's a great one, right? Motion to put Rolling Stones' Slave on the playlist based on the number of times Mick says, do it. Done, Elizabeth, done. Am I going to do that right now? I'm doing it right now. It's called Slave. What do you mean couldn't load the page? What's wrong with Spotify? Is Spotify down? How can we live with Spotify down? All right, it's better now. We're waiting. Still waiting. That's a Talking Head song, and it's also on the playlist. No, Spotify down? Couldn't load the page. Why? Why you do this to me? Why? Why you do this to me? Vote Chris Albert out, says Robert McNeil. I don't know. Dr. Turk was found guilty of the least charge, right? The lowest charge of manslaughter. Island Girl Diana. What is he facing time-wise? Up to 20 years. He's already been in jail for 5. He's been sitting in the Norfolk County Pokey for 5 years. And so his sentencing is happening in May, and we'll be back for that. Was that justice for Katie McLean? I don't particularly think so, but our chat was completely split on murder 1, murder 2, and manslaughter. I don't know, you guys. I guess Spotify's down, but it has my rain sounds working. I just can't search up anything, but I'll get back to that later. So don't worry. I know Spotify's been down for a hot minute. See, it's not me. All right, good. Karina, there's at least one song named after you. Bob Weir used to sing it with Rat Dog, and I think it's also a Bob Dylan song, right? Didn't you tell me your mom named you after a Bob Dylan song? Hang on. Thank you to Timothy Chalamet, by the way, for taking on the role of Bob Dylan. And now my teenage daughters are totally into Bob Dylan now. So shout out to Timothy Chalamet. Because that was an amazing movie. Did you guys see? Oh, it's been down since 8 a.m. All right. Well, I guess that's the last time I was listening to rain sounds. The movie is amazing. Did you guys see it? The movie with Timothy Chalamet playing Bob Dylan. Why can't I think of the name of it right now? I really like it. Oh no, have you polled your audience? How many of us were with you for the first trial versus new viewers for trial 2.0? All right, we could do that. We could do a poll. Interesting. Do you think Bob Dylan is on the spectrum? I don't know, but you know what they say? They say there's a fine line between genius and insanity. A complete unknown. Thanks, Nicole. It is called a complete unknown. And do you know that I was like halfway, all right, even more way through the movie before I realized that was Ed Norton playing Pete Seeger? Hang on a second. A complete unknown, like a Rolling Stone. So yeah, highly recommend. Bob Dylan's kind of a dick in real life. I remember seeing Bob Dylan, and I want to say maybe it was at Nassau Coliseum. It must have been Nassau Coliseum because I was like in the first row, and it was like probably at least 15 years ago. Like when you had like an old flip phone, right? And I was taking a picture of him, and I nearly got tackled by a security guard. Mr. Dylan does not allow photos at his concerts, and I was like, he should be happy people want to take a picture of him. Like what? Yeah, so Ed Norton plays Pete Seeger in the movie, and Timothy Chalamet plays Bob Dylan. He studied 5 years to get everything down and learn how to play the guitar. And also, Monica Barbaro plays Joan Baez, and she's amazing. She's amazing. She was nominated for a bunch of awards, but I think she was nominated for the Oscar, right? She was nominated for the Oscar, but she did not win. But she's a lovely girl. And she was also in. I'm like, what did I know her from? See, we have to talk about other things sometimes. Otherwise, it's not healthy to just talk about how mad we are about the Karen Reed trial. She was in Top Gun Maverick. That's what she was in. She was one of the female pilots. She was awesome. And I love Ed Norton. And I loved Ed Norton because remember the movie Primal Fear. Hang on, let me just go back to that. Wasn't he in Primal Fear? And because of all of my work representing the victims and survivors of clergy SA against the Catholic Church, that movie really stuck with me. Oh, he's also in Fight Club. Yeah, he's good, but he's like unrecognizable. Yeah, he was in Primal Fear with Richard Gere. That was a great movie. You guys remember that one? Laura Linney was in that too? I didn't realize that. Wow, that's an old one, 1996. Chris from Toronto, fellow Deadhead, love the show. Yes! We will get by. We will survive, Chris. I accept any and all Grateful Dead quotes in the chat at all times. There's the poster behind me, the Dead and Company poster. I was in Las Vegas for the shows a couple of weeks ago with my girl, Andrea Burkhart, who is also a law tuber. Many of you know Andrea and her husband, and we had an amazing weekend, and it was her birthday weekend, and it was so fun. I cannot, in good faith, recommend any complaints against the judge. So, as an attorney, I just can't allow that in my chat. So I'm gonna just delete it. Don't take it personally, but it's against the ethical code for me to even suggest that you could make any sort of complaint against the judge. It's just not something that I can do. The sound is not up yet. We may need to modulate the sound. So if it's not loud enough or I'm too loud, let me know. But their sound's not even on. Really, Boston 10? Get with it. Let me see if I can find another feed that has sound. It's gonna be one of those days. Well, Law and Crime doesn't have sound either. Blessed be the fruit. Yep. Well, there's no sound, guys. There's none on Law and Crime, and there's none on Spotify is down. There's no sound. Yannetti is there. And this is like a secret proceeding, I guess. I don't know. Because Elizabeth Little is on this feed and she's at the podium and there's no sound. Is it me? Okay, no, because everyone in the Law and Crime chat is whining about it too. Well, if the sound comes up, we'll be here for it. If not, let's see who's in the courtroom. I spy Meredith, SD, Kelly Reed, Nathan Reed, Bill Reed, Janet Reed, Craig Bates, man of the tiny desk from the first trial. He's on the end of the first row. This is Victoria George sitting. Maybe she's at the tiny desk, the TV tray table. And the courtroom has no sound because why should the pool camera have it together? I have the closed captions on. However, they're just not picking up anything because there's no sound. Not me. Court TV has sound. Okay. All right. We'll try it. You just can't, you can't make this up. And we can rewind it, so no worries. Maybe Court TV is like, yeah, we'll be the pool camera, but none of you other people can have the sound. You are correct. Here we go. Thank you so very much. You guys are awesome. We're taking it back to the beginning.
Yay. All persons have any business before the Honorable Beverly Coney, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near to your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
God save the Commonwealth.
22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning,
Puppy
Mr.
scissor hands.
Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
The sighing.
Yes, Your Honor.
The
You did not
sighing.
file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
We have sound now too. You don't need to redirect people to
Your Honor,
other
the defense
streams. Thank
respectfully
you.
requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th.
Show me the metadata.
2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial.
Yeah.
I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video,
Right.
in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
Okay, you're all set. Oh, let him get up and make some wild accusations against the defense team. Wait for it, everyone. Wait for it. Dirty. He's dirty.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to.
It's difficult to follow that they want the freaking metadata. It's difficult for you to follow. All right, my head's going to pop off and roll down the street. So where's my head bucket? Somebody has Melanie Little's head bucket name in the chat because my head pops off. It's difficult to follow what they want. He's unreal.
Come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed. And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department,
It's not, you just said it's not there.
and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file?
She's saying, so now we can go and
Okay,
forensically image
I
the
really don't
detective
want you
file.
talking to each other. I want you talking to me.
I really don't want you talking to each other, and I want you talking to me. How about this? You don't know how to rule from the bench. You don't know how to tell them what they're entitled to. And he's saying they have an open invitation to come, but he just said it's not there on the system, right? They didn't have anything. They spent $12,000. They tried to get their costs back, and you wouldn't give them their costs. Listen to this.
The Canton Police Police Department detective file?
No, not the detective file, sweetie, he's going to say.
We've been in our request in the
Okay, so
past.
I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private
Mhm.
information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view.
Okay, so what? So you're just not you're not even going to address the metadata at all? You're just going to move on to the field trip? I told you this is why Shaka from Land of the Lost is our mascot, because this is insanity.
I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported last time. We were on a bus.
Can't they just
As I
drive
stand here,
her?
I can't remember if we were we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in
Yeah.
a separate vehicle, which
That's
we
right.
can
Real
provide.
easy.
And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors.
Then they
We
can
need
take
defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and
fine.
the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had
Yeah, the
reluctance, I
Lexus.
thought it was unfairly prejudicial to the defense. If they
They
decide,
want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see Counsel Tybar about this anymore?
Yeah, they should not make that public because people are going to show up there and really they need to be like blocking off the streets when they go there. But at least that they agree that, the vehicle will be there because that was not in the order. It was never even addressed. So, but the first motion of the day to compel a forensically sound copy of the Sallyport video with metadata was just, no grave concerns about that. Keep in mind also, it has been released that Hank Brennan has already been paid something like $234,000 by the taxpayers in Norfolk County. We're a little behind, so I'm going to FF a little bit. And originally, you may recall that they tried to pull the wool over the eyes of the Norfolk County taxpayers by saying they were only going to pay him $75,000 at $250 an hour, but he's already been paid pre-trial $234,000, around those numbers, somewhere around there. And how much do you think his trial bill is going to be? He'll probably bill 24 hours a day for the entire time of trial and pre-trial. So you're going to wind up paying him close to, I don't know, probably $750,000 because none of the 50 plus attorneys that are already paid a yearly salary by the Norfolk County DA's office wanted to try this case. So he's a hired gun. That's how much it's going to cost. We'll see what it costs in the end. Could be $1 million. Melanie Little's left swiping StreamYard. You're correct. Could be. Yeah, we should take an over-under on that. Anybody want to be the bookie? I know it's a long sidebar just to decide whether or not. I think last time they did the field trip, right? Like maybe on one of the first days of trial. And so it's a matter of when they want to do it. Do they want to do it in the beginning? Do they want to do it after the jury has heard a lot more about 34 Fairview and then take them? It's strategic. Usually they do it near the beginning. We saw that in the Turk trial, and I think in this trial as well. They also did it. There's no sound right now because they're at sidebar, and they turn off the sound at sidebar. But in the beginning, nobody had sound, so we had to go to court to create the whole thing. Crime scene, tell you anything else? Love you about that.
All right, so on the defendant's list, I don't understand the motion regarding
Of course, she doesn't.
Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay,
I will do that.
all right, thank
Thank you,
you.
Your Honor.
You asked him to specify, which he wasn't going to do. He just said, we're reaching it. Well, what is your agreement? And then when he tries to specify it to you, you cut him off with your snarky tone. Here we go again, already with the nonsense. Thank you, Kim Jong Kanone.
Okay.
It was like
So
the PowerPoint was originally like something like 150 something
Lieutenant
pages.
Wing,
Okay, wait, Garrett Wing, my guy.
docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
Who said we need
All
a
right, I'll hear
hearing?
you.
Why do we need a hearing for Garrett Wing when you didn't have a hearing for James Crosby? She is so insufferable.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial is upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this
Oh my God, I
person
hate him
should
so much.
have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It
Supposedly.
doesn't appear that Mr. Wing is a certified
Supposedly. He said it again. I'm going to rewind it. This is what we do here. Supposedly. Okay? James Crosby is a dog behaviorist. He's not a medical doctor. We don't even know what he's been qualified as an expert in, but the judge just allowed him, despite a very well-written motion by Bobby Scissorhands Alessi. Now she's going to allow him to be heard on this. I need like a vomit bucket. It's like this is going to be like a Monty Python movie. My head's going to pop off. There's going to be blood everywhere. I'm getting thrown up in a bucket. This is revolting. Okay. This is exactly how a prosecutor should not act. And you are watching this in real time, in real life. This is real life.
to come into court and give an opinion that a abrasion is supposedly a dog bite.
Supposedly.
It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Kind of like Crosby? Oh boy. Let's hear it, Bobby. Go, Bobby. Scissor hands. Here you go.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those. So those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right.
Okay.
That has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites two specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby.
That's right.
That a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with the wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby.
Come on, Court TV.
And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of
What's good for
Dr.
the goose?
Crosby.
That's another motion. That's what we're going to hear now.
Understood. And I was just
It's
going
not-
to say, I am not going to get into
Is this
the
freezing on your end
basis for
too?
that. I just wanted to, because,
Just go ahead. Just move on.
yeah.
Just move on. No, let him
So
freaking
my
talk.
request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on, at a minimum, wait for that determination until the court reads the report
Right.
of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay.
Right. Why does she always try and
All
shut
right,
him up? And
so
she never
there's-
tries to shut Brennan up. She let him go on and on and on and lie in open court. But every time somebody with something to say who's actually intelligent is speaking, she interrupts them and does not let them finish. It's revolting. Let's see if somebody's got a better feed. You say that Channel 10 didn't have any sound before though, so it takes a minute to switch because we have to find out where we were. Hold on. I'm gonna try though. See if we can get it. No, because they're way behind. That's why it's not jumping, because they're way behind. All right, we're just gonna keep with what we have. We're just gonna keep going.
There's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am
In
not
what?
going to reconsider
In
whether or
what?
not Dr. Crosby's an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't.
Okay. If you weren't here for the first trial, this judge ruled during the first trial that nobody who was not a medical doctor was not allowed to testify with regard to causation of injuries. Okay. The crash daddies, one of the crash daddies, Dr. Rentschler, is a biomechanical engineer with tons of qualifications. And his job was, in addition to recreating the accident, was to figure out if the injuries to John O'Keefe's body were caused by the car and if the damage to the car was caused by the body of John O'Keefe. She would not allow him to testify about the injury component because he was not a medical doctor. Put a pin in that. Now, this trial, whole new trial, this James Crosby, who is not a medical doctor, he's got a degree in veterinary science or something, not veterinary medicine, that Dr. Russell, the highly qualified doctor with decades of experience in dog bite injuries in the ER and prisons, was forced to sit through 2 full days of voir dire to see if she was qualified. She's not even going to reconsider her information, her ruling on Crosby, who's not a medical doctor, who's a behaviorist. She rubber stamped him in, and she's not going to. We don't even know what he's an expert in, what he's been qualified as an expert in. We have no idea because the papers that were filed by Brennan are facially insufficient. We have no idea. He's a dog shrink. Yeah, exactly. And he also helps out at autopsies when people are mauled to death, usually children, by pit bulls. That's what he does. But we really don't know what he does. But she doesn't care because she's going to not reconsider her. This is like bias at the highest levels that only has been seen in Delphi. But Judge Kim Jong-Kanoni is looking at Judge Fran Gull, and she's like, hey, Gull, hold my white claw. Check this out. Watch me. Watch and learn. This is disgusting.
Don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think
She's
that
almost
you can certainly
afraid to
talk
tell
about
him that.
measurements that may have been made, but I don't see how he can testify.
There's no ruler. They used the hospital band on John O'Keefe's autopsy photos, the hospital band on his arm to do measurements, okay? There's no ruler involved here. But, okay, so you're going to let him say that they're dog bites, but just not that they didn't come from Chloe? Okay, because they went to visit Chloe allegedly because they found her and did some moldings, but we all know that forensic odontology is junk science because Lally even said that during the last trial. Wow.
That this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well-respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds.
No.
That is the whole purpose of having
No.
the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. This
Let us point out, any of you have dogs? Do your dogs' mouths change in a 3-year period, 3.5-year period? Dogs lose teeth, their teeth shift. We don't even know if this is really Chloe. But he wants Crosby to be able to testify based on his molds of alleged Chloe's teeth. Some people have think that Chloe's been 6 feet under since shortly after the rehoming, or around the time they said that Chloe, it was rehomed. No, it's junk science. And do you watch the judge when she tells Brennan this? It's almost like she's frightened to tell him no. I mean, is it just me picking up on that vibe? It's like she's frightened to say no to him. It's so weird.
spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular,
It's laughable.
Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of
Yes,
certainty
Leanne. It's starting
that these
Tuesday.
wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
What's the difference, jackass?
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
It's an uphill battle for you, I'll tell you that. Wow, she actually told Brennan no, or didn't really say no. She's just said it's an uphill
Thank
battle.
you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
You know, messy with Alessi.
Did you want to reply?
Thanks, just Joey.
I would simply suggest that there is no authority that I'm aware of.
You're not
that
aware of
prohibits
much.
Exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right. Thank you.
Thank you. You're all
The
set.
substitute chemist, is there any objection to the substitute?
Is Chloe now the third party culprit? Did I miss something? Did they name Chloe as a third party culprit? They're just saying they're dog bites. They were not caused by an exploding tail light. Okay, substitute chemist, motion number 663.
Chemist. It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
That's the chemist. Is that the
You
one from
both
Bodie
have
Labs?
motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio-visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow
41.
the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after.
Wouldn't that be the important one to
Okay.
turn over?
Who's
Going for
arguing this for the
openings?
defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right, I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible.
Because I'm the
That I know it
gatekeeper.
will be coming into evidence before I let you put it up there.
I'm the gatekeeper to
That
hell.
was the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay.
Thanks, Pam.
Thank you. Can I have the defense what you intend to put up?
Just a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've
No.
had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew
Yeah.
of those clips. to
Dribs
the
and
defense.
drabs.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to.
Yeah, we give them everything.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes,
So,
please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case.
Maybe you could hire an
I don't expect
actress.
There'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
But we could have somebody.
We're going to
playing
go to
both the
central
state police, or we
casting
could-
and we're going to hire someone who sounds the nastiest, Judge. I want to point out that Nancy, Madam Court Reporter, is not here today. It does not appear that she will be assigned to the Karen Reed trial. She did work on the Dr. Turk trial, but here's the new court reporter. She's got a different athletic supporter. Hers is black that she speaks into. This is the system they use in Massachusetts. I guess it's a form of stenography. They talk into what Madam Court Reporter Nancy's one looks like an athletic supporter. This one is black and looks a little more current. This motion has to do with all of the statements that they want to use against Karen, her text messages, anything she said in any of the documentaries, or perhaps in Vanity Fair articles. And Hank Brennan wants to hire some sort of actress to come in and read them. And the defense is not objecting to this. Karen knows that everything she's said publicly can be used against her, and she's not afraid. Yesterday, when a reporter asked her about it, she said, "Come at me, which is something her father said the day before. And she said, anything I've said, I would say again. So good luck with that.
Find somebody that's agreeable to the defense, but I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
Play that role, because this is like a movie.
Yes.
I could audition to be the reader. Yeah, that's a great idea. Yeah, this is a movie. We're all here. It's her world. We're all just living in it. It's part Truman Show. It's part Groundhog Day. It's part the worst movie you ever saw. Because if you were to script this in a Hollywood writer's room and try and sell it as a pilot, they would laugh you out of the office. They would laugh you out. They would say, nobody would believe this. Nobody would ever believe this. The sound is cut right now. It's not us, it's them. Well, apparently Aiden has to be in court. I don't know if he's there yet, but they're going to hear his motion.
Your Honor, thank you for the time to consult with my colleagues.
Yeah, I think
I'm
Will
not-
and I should come in and read.
I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name. Mr.
Nicholas
Garino to
Trooperino.
recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
I don't see any of the O'Keeffes in the
Wherever there's a
gallery.
witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant.
Okay, but remember Higgins read both sides? Beta Boy Higgy read both sides of the text messages? Messages between Mr. O'Keefe and the defendant.
Through the witness. Text messages between Mr. O'Keefe and the defendant.
Amber Heard.
There is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly
He's
as
a
police
loser.
officer, I think is
Trooperino.
impression. I think objectively
Okay.
we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
And then you can say to him,
I-
aren't these the text messages that you couldn't find? Didn't you not find 32,000 of these text messages in Matthew Farwell's phone after he murdered Sandra Birchmore? Trooperino? He's going down.
I would disagree gently with Mr. Brennan. That's
Gently.
exactly what the proper protocol is. If Mr. Garino is the one who found it, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages. previously, I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or
Right.
1 time. But to have somebody else come in or other individuals come in
Yes,
to
put your
act as
hamburger.
readers, I think that is not in keeping with the ordinary course of presentation of the evidence.
Mhm.
It just doesn't make
That's right.
sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I
Mhm.
don't know who these individuals would be, and the text messages are admissible because they're their statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
I nominate Amber
All right.
Heard.
If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
So you're going to pay them. You're
I
going
haven't
to,
identified anybody, but I
in
can get a
addition to
male
the,
or and a
I'm sorry, in addition to the $234,000 that you are being paid as the hired gun on this case, you now want to pay readers to come in? I say Will and I can come in and we'll do it for free because we did it on his channel one night and we read their text messages from the whole entire day. I'll allow it. Anybody wants to make that motion to the court? Maybe I should just make that. You know who could do that? Andrea Burkhart could make a motion to the court. She did that in Delphi. She made motions in Delphi. It is supposed to be justice. This is insane at the highest level. If you are just watching this trial for the first time, I have secondhand embarrassment for every single one of these people involved in this case. Is there anybody who's watching today? Just put a 1 in the chat if you're a live viewer, if you did not watch the first trial at all and you're new. Welcome. You have no idea what ride you're in for. Buckle up, buttercups.
female.
All right.
And that's
Right.
A female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male or and a female.
All right.
and that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed.
Right.
The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people
Mhm.
with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all.
No.
I understood it to be to take out all infliction.
Right,
and
because they're going to
completely
do that.
Right.
No.
I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly
Prejudicial.
objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Go.
Thank you.
How many things have you done already that are so inappropriate and you keep doing them? He said he had no objection to Mark Betterow being admitted pro hoc vice as part of the defense team. He said, I have no objection to it. And then he got up and said, but I'd like to share a few thoughts. Then he shared a few thoughts and the judge said, well, I'm going to have to consider his thoughts. And meanwhile, she's been telling the defense for 3 years, if it's not in writing, I don't consider it. He says a lot of things that aren't true. He also said, I have no problem with ARCA. I welcome ARCA. Let them testify. But I have a few thoughts that I'd like to share. And that is when she had her grave concerns, took a half an hour time out, and he tried to basically have them disbarred and thrown off the case. He's dirty. Of course she's going to consider it. I've only seen we have like over 10,000 people watching it. Only 10 people have put in the chat the number 1, which means that you're watching this trial for the first time. So it's wild.
All right. Defendants.
Yes, that is, I think her name is Tara sitting there. That is John's girlfriend from 25 years ago. He's the one that got away. She's been in every single documentary holding a picture in her lap of him. It's wild. She's moving on. She'll consider it though. She'll consider it.
Thank you. All right, defendant's motion for specific discovery, paper 638, Jimmy. All right, who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
That's what I was thinking.
There's
Kate
no
Peter. They'll bring Kate
authority
Peter
for
in.
that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we
Sorry, I gotta take that back a second.
either a refusal or a we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Number 5? Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses. Motions regarding that.
All right, here we go, Crash Daddies.
So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect would be.
Let me explain to you what's going on here. He wants the defense to turn over all materials that were given to the ARCA witnesses, who are biomechanical engineers who are highly regarded accident reconstruction experts who are hired by the U.S. Department of Defense, the NHL. They've got some pretty high-profile clients. He wants the defense in the Karen Reed case to turn over all the materials that they were given to do their initial reconstruction. The problem is the defense didn't hire them. The FBI hired them. And so the defense is not necessarily in possession of all the things the FBI gave them to do their reconstruction. So he's chasing his tail here because the defense doesn't have it. This is a very hollow argument, but it doesn't matter because he still has no idea what he's doing. He has no idea what he's doing.
In the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense is
Notice how
provided
she
that they
doesn't
have
interrupt him.
retained-
Notice how she doesn't interrupt him. This would have been a perfect time for her to say, but Mr. Brennan, we all know they were hired by the FBI, right? What authority do I have to order them to bring in confidential materials that were turned over to them by the FBI? That would have been the perfect opportunity for her to say that, but she doesn't challenge him on anything. She doesn't.
The ARCA witnesses independently, provided that they have retained.
Secondly,
the defense is provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the
are they grave
notice from the
concerns?
defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so
Steadfast.
my expectation is if the ARCA witnesses testify.
Oh, really? Oh, that's so funny that you say that. You've been like steadfast about discovery deadlines. How about all the freaking Sallyport video that wasn't turned over until after the first trial? How about you've been turning over Magical Mystery Sallyport video has been appearing since the mistrial was called. The latest of which was last week? Yeah, there's so many Brady violations here. It's like the Brady Bunch. Judge Summer in New Mexico would have had this case thrown out on Brady violations 6 months ago. If she was there during the first trial, she would have thrown it out the minute that inverted Sallyport video was put up on the big TV, and it was testified to by Buchanan that it was a fair and accurate representation of the Sallyport on January 29th of 2022, but it was inverted. Mary Marlowe Summer, I think that was her name, the judge in the Rust trial for Alec Baldwin in New Mexico, would have tossed it that second. But you've been real steadfast about your discovery deadlines. I think I threw up a little in my mouth right now.
Testify. They would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the
I see
court
3,700, but hit the like button.
have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Smooth as butter. We have an emoji for Alan Jackson because he is smooth as butter.
I want to go in reverse order briefly, if I could, concerning the discovery deadlines. We have continued to receive new notices of discovery from the Commonwealth.
One was yesterday.
Well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What do you think a timely manner is?
Well, it didn't take her long to interrupt him, did it? Yeah, he sounds a little bit off today. That's a song in the playlist, by the way, by Five Finger Death Punch, and I highly recommend, if you don't know the song A Little Bit Off, that you listen to that at the loudest volume, because I can't play it, I'll get stricken. Five Finger Death Punch. The playlist for the trial is linked below. It's a Spotify playlist. It's called A Little Bit Off. I'm a little bit off today. I'm a little bit off today. I want everyone to F off today. They all sound sick. They need immunity boosters. They've been working 24/7 since they've all been in town. And so it didn't take her long to interrupt him.
We'll turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of
Pay
the
attention.
13 or however many points there were?
Wake up.
Because this is on what you filed.
Pay attention.
So this is not unusual. A party says, we asked for all 13, another party says, we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically?
Yeah, she just
that-
accused the defense of lying, didn't she? Did you read between the lines there? Did you read between the lines there?
Mr. Jackson should address?
Yes. Their response is that it's not in their custody and control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have.
Oh, so you can't tell her anything that they've given you?
All the text messages, all the emails between the parties. And if the defense's position is not in their custody and control, well, it's certainly in the custody and control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs.
Oh, sigh emoji.
We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development.
Your tolerance?
is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay.
His
So address
tolerance.
number one, Mr.
the
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So
Desperately
address
does
number
not want
one,
it.
please.
Yes.
I
Okay.
am.
Don't you
That's what I'm
cut him
doing.
off. You let him go. You're afraid of him. You're afraid of him because he's Hollywood AJ and you're afraid because it's a privilege to practice law in Massachusetts. She tried. She wanted to pull his pro hoc vice status, but she couldn't because under the U.S. Constitution, which, yeah, Massachusetts is also supposed to abide by, she's entitled to the counsel of her choice. And she tried so hard to get rid of him. But let's hear that again because it deserves a second pass.
Has anticipated.
So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So
Desperately
address
does
number
not want
one,
it.
please.
I
Okay.
am. That's what I'm doing, Your Honor. We have provided on April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding
a full day at
testing,
voir dire.
preparation, things that are
I'm sorry.
normal cross-examination.
Should we direct her to the trial channel? Because the trial shout out to the trial channel who has clipped each witness's testimony into its own video, even if it was on different days, cut out all the dead air, cut out all the sidebars. Go there if you want to watch a specific witness's testimony. Perhaps the judge would like to go back and rewatch the voir dire that happened before the last trial. It's unclear to you. Maybe it's unclear to you because it was a year ago and you need to go rewatch it.
Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on
Injuries?
on the biological
I get
side.
there was a difference between the
and
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was.
And remember, Judge, because you would not let Rentschler testify about the injuries because you said he was not a medical doctor. Remember that?
In their expertise.
Refresher
We have
recollection.
not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
She has all the answers. Elizabeth Little. Thank you, cruelty-free chapstick. And thank you, Elf, for gifting. Thank you,
Ms. Little
membership.
I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the
Right.
Department of Justice.
But can
So-
they testify as to what they did?
Yes, that is on. That's
Can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Counselor Tagbar, please?
They cannot turn over confidential information with the FBI. Look at Bobby's grabbing his elbow. Hang on. Ooh, I love a good defense powwow. Love it. Somebody asked, who is the tall man sitting with the reeds? The tall man on the very, very end is Craig Bates. He's on the aisle. He was the AV squad for the defense during the entire first trial. He was the man of the tiny desk. Macbeth's Inferno wanted to know. Macbeth's Inferno, Divine Comedy, 9 Circles of Hell. We have called this a Shakespearean tragedy at the highest levels. She is Lady Macbeth, and we're living it. And she wanted to know who that is. It's Craig Bates. He did a show with me. He's amazing. We love him. We love him with all of our hearts. Nurse Kella's here. She says AJ's lymph nodes look swollen. Thank you on top of your super sticker. Appreciate you. I mean, your super chat. Yeah, fun fact, I auditioned for a 5-finger death punch video when I was in LA one summer. And it was for a video that they did. There was a female president, and I auditioned to play the president in that video. So I started listening to them back then. And I forget the name of the song. I was in the final 2 and I didn't get it. And if you see the woman who plays the president, you'll understand why. But thank you so very much. Mr. Crosby's orphaned methodology. Leanne breeds and shows dogs and says the dog bite changes, particularly in a geriatric dog, which Chloe is. Thank you, Leanne, for your super chat. Norman is here. Thanks for the 10. I have a dental plate I had not worn for 3 months, and when I finally did to try to put it on, it didn't fit, and I do not chew on bones. Thank you, Norman. And I think we can all agree that a dog's dentition is quite different from a human's. Meeple Marcy Sketty Stain says, my German Shepherd had an impacted canine tooth removed, but for the cool low price of $2,000 last February, and he had a few others removed, but he's still cute. Thank you for your super chat, Shannon. I actually get a visceral reaction of disgust when I hear Breenan's voice. Waterfall footage, 100% altered, says, I have to see if it's admissible. Oh, Bev, you know it's clips spliced together, out of context, and probably her voicemails on replay. You let fabricated video enter your courtroom. You'll allow it no matter what. Thanks for your thoughts and for your 20. Mama She says, Chad, grab your red Solo cups to catch Mel's blood when her head pops off. Thank you, Mama She. Double M99 says, thanks for the 10. Hank reminds me of the guy who sneaks onto the last lifeboats on the Titanic. And then somebody said, he is no Billy Zane. And that's another fun fact. I once met Billy Zane at the Sunset Tower Hotel Bar. And he does not look anything like he did in the Titanic, but he and his friend were very fun to hang out and have a few drinks with. That also, a long time ago, not that long ago. I don't know, in the last 8 years or so. He's still out there. He's still hanging out at the Sunset Tower Hotel Bar. I think we're a little behind, so we can fast FF it a little bit. Somebody's got crutches over on the O'Keefe side. It's empty there. There's only about 4 people there. None of them have the last name O'Keefe, as far as I know. I'm not sure where the mother and father or Paul are today, but it's not for me to speculate. Okay, Yanetti's back at the table. Not sure. He looks like he's packing up. Thank you, 1199. Billy Zane is like fully bald now. He looks like a Massachusetts State Police trooper.
All right, so Mr. Jackson, you're saying that the ACRA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ACRA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's 2 issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the days.
She never presses Brennan for details. You notice that?
September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice or the U.S. Attorney's Office was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA
Do you
to
know?
answer their questions.
Do you know what information was provided?
Yes, it's in the report. There are
All right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then
from
you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so
That's what we provided to them.
when did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
I don't know where he met. Maybe he had a doctor's appointment. Maybe he had a thing with one of his kids.
That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect.
She is dying to know what the feds want and what they gave them and what they know. Are you picking up what she's laying down here? She seems desperate to know what the defense team gave the feds pursuant to the federal subpoena that they served on the defendants for their file.
Expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said, I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA.
March 25th?
I'm sorry, on March 26th.
I thought it was 25th, but what else?
All right, Mr. Brennan, I'll hear you.
No.
This is the very issue I've been concerned about since the beginning of this case.
Look at Meredith's
And I've
face.
made-
If you're not looking at your screen and you're not driving, come back. Oh boy. You ramble on. That's in the playlist. Wow. He's out. He's outraged. Hold on. Hold on. You gotta see this. Are you ready? His faux outrage. Who's going to change their name to Hank's faux outrage? Ready? Here we go.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this
great
very
concern.
thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never. But it was to preclude the defense from trying this case by ambush.
Oh yeah, ambush.
And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control. That's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages.
Oh, he's triggered. He's triggered.
And if it exists, I would like to see it. I think I'm entitled.
He's triggered.
The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that.
Really?
The ARCA witnesses provide a report does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements.
Do it.
And then expect to come in with new opinions and information and reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited.
Yeah, you know why? Because there's limited funds. You know how much the feds paid ARCA to do that reconstruction work? Probably a little bit around the amount of money that the county of Norfolk has already paid you. Over $200K, north of 200, maybe 200, 250. This defendant has limited resources. So no, they couldn't go out and hire more experts because they already have a dozen that Karen Reed's defense fund is paying for, which, by the way, if you'd like to donate, the link is in the show notes below. Her attorneys are working for free. They're all pro bono because they believe so fiercely that she is being railroaded and framed by this Commonwealth. Today is, Karen Reed is still being framed. You can get this on Microdot's website, a framed mug. You too could have hired ARCA, Mr. Spanky Brennan, but you didn't. You didn't. When you have the law on your side, pound the law. When you have your facts on your side, pound the facts. When you've got nothing on your side, pound the podium. That's what you're seeing him do. He's pounding the podium. Literally. You're in Gilead, my friends. You are in Gilead. It is under her eye, and we're all here living in it.
They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welsh's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery.
Yeah, except the Sally Port
Pursuant
video.
to the orders, so that they would be held to the same standard.
Bullshit, man.
And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing.
I think Trooper Paul is really a match for the Crash Natties. Do you think Trooper Paul is really going to be able to do anything here? If you want, I know you weren't here for the first trial and you probably didn't watch it, but maybe you should just go back and watch their testimony. Because not only were they subject to a full day of voir dire, they were also subject to testimony and cross-examination. So you already know what they're going to say. There's nothing new. They're not going to say anything new. He's insane. He's insane. Meredith is trying so hard to keep it together. And kudos to her. I'd be busting out.
This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses. They have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now, and have new opinions after we've already told the jury
Yeah.
our theory and our science and not have a chance?
There's no science behind your theory. First of all, let's clarify that. Number two, John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. That theory is not changing. We saw Wendy Murphy post a story on Twitter telling us your new theory. We don't know. She said that's the story you're going to tell, that John O'Keefe kicked the taillight and shattered it with his foot, and then his sneaker fell off. He did a pirouette and hit his head on the frozen rock hard ground. You still haven't shared that with us in open court.
To rebut it or
So
consider it? I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need, or witnesses that we've decided we don't need in this case, and scheduling.
Here's
If
what
it
you have
wasn't for-
time to do. Here's what you do have time to do. Drop the charges. Drop the charges, dismiss the case. You got time to do that. You might as well do it because you are wicked, wicked afraid, wicked scared of ARCA. You could get up there and you could bloviate. Somebody has that name, bloviating Brennan. We said that one day. You could bloviate all you want about how you're not afraid of ARCA and you welcome their testimony and blah, 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 yada, yada, yada. But we know you are petrified. You are ruining your career by taking this case. And I mean, really, karma knows your address. So there's that. But you know what you do have time for? Go back, rethink. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. And that is why you can never, ever, 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 we are never, ever, ever getting back together. And you are never, ever, ever, ever going to convict Karen Reed.
Obvious this was going to happen, I wouldn't be so upset about it. At some point,
So
the
obvious.
defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in.
Metadata?
This is an effort
Sally
they
point
decided
video?
to make and wait until March,
Exculpatory?
but February
What's on
7th,
the phone?
2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I ask this court to do.
Wah, wah, wah. Boss baby emoji.
Your Honor, what appears to be feigned indignation is just not
Feigned. I said that.
consistent with the facts.
Oh, outrage.
We didn't receive Judd Welcher's report until basically February 2025.
Right.
We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Oh no, he's back. Oh no.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judge Welcher's PowerPoint were by exclusion. Attorney Alesi had concerns about certain things in the report.
Alesi.
So we took things out of the report.
It's Alesi.
There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November. And then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines.
By February 5th.
The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alesi,
Oh,
who's much more facile with the facts.
Oh my God, I love how he corrected his pronunciation. Listen, Mr. Alesi, because he's just doing it to be a dick, Brennan. He's just doing it to be a dick. Let's hear that again.
Mr. Alesi. According to Mr. Alesi, who is much more facile with the facts of what's in Judge Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there is no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you.
All right, so rule from the bench. I dare you.
I think is the only thing left the motion to sequester Aidan Kearney to remove him from
Carney.
the sequestration order.
Carney.
Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes. Where do we stand with that?
Yes.
I thought that you were going to.
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct.
Conduct related to this case.
Third parties' opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that
Thank you.
assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that.
I need that so I can
Do you
report
have
back
it?
to Marcy.
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing.
Oh, that's so funny.
I need
'cause-
this in writing. I need a Commonwealth's response.
How about this? Okay. Under her eye, Gilead, is she like a commander now? She doesn't want Eliza Little telling the worldwide audience this in open court. She doesn't want her telling this in open. All of a sudden, she needs it in writing. Anytime Brennan gets up there and spews his word vomit to the world, it's never, ever, ever in writing. But she wants it in writing now because she does not want her telling the worldwide audience that Trooper Michael Proctor was fired for his conduct in this case. And that the 3 other officers were also disciplined for their roles in this case. This is this is corruption at the highest level. I'm just
We
going to call it
needed
what
to
it
have a
is right now.
I
Hold
need,
on.
I need this in writing. You know what? I do need that in writing.
Yeah, I do need it in writing because I don't want you telling me.
I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All
Excuse
right,
me?
get it to me today. I'll decide it tomorrow.
She's
Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay.
he's allowed to, but you're not.
You know what?
You know
what I
what?
need is I wasn't expecting this here today. So what I need is the paper number.
What it's kind of your fault for not knowing what motions you have not ruled on yet because you're too lazy. It's kind of your job to know that. So I'm sorry that they've ambushed you with a motion that you haven't decided, and you now do not want her to say things to the world that may make you look like an idiot and the Commonwealth. Are you kidding me? My head's popped off. It's gone. It's gone.
I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you would.
Well, he doesn't want any of the conclusions to come in.
All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right.
Yeah, I didn't realize
Jim,
that
I
I
need
didn't
that.
rule on that motion. So yeah, you're going to need to put it in writing. God save the Commonwealth. We get to FF through this break maybe because we're a little bit behind. So let's just see how far we can get with this. This is gross. It's gross. If you're just joining this trial for the first time, it has gotten so much grosser since Hank Brennan was hired as the hired gun to prosecute this case. It has gotten so much grosser because he plays dirty. Lally tried the entire case himself last time, Adam Lally, the guy with the shark fin hairdo. And he was a little dopey, but he wasn't evil. He wasn't evil. He wasn't that smart, but he did the whole thing himself. And he really, this guy is just evil and he's dirty and he's loose and he has no morals or ethics, and it's disgusting. So welcome if you haven't watched this trial the first time, because you're in for some must-see TV. Thank you, KOB. Let's go. Free Karen Reed. Thanks for your amazing coverage of the circus. Thank you for your super chat. Oops. I addressed these before, so let's just get back to where we were. Nightclub says, thanks for your super chat, how easy it was to do that IA video. You can't tell me Hanky was not using the editing app on Karen Reed's tail light. How easy is it to mirror a video? How easy is it for 42 minutes to disappear? Cover-ups are easy. Yep, they are. Yes, they are. Thanks for your super chat. On top, go to add new song we heard this morning. I don't know if it's on Spotify, but I'll look. Spotify's been down all morning. I don't know if it's back yet. Maybe you guys know. Mike from Providence is here. With all the confusion about McCabe's Safari tabs, why couldn't they get someone from Google to say when the Google search results were sent to her phone? They do have a witness who's coming from Google this time, I think, and I don't know if it's about geofencing or if it's about the 227 search. So great question. Thanks, Mike from Providence, for your super chat. That was me, Melanie, with those songs to add to the playlist. Thank you very much. Nothing to see here. Appreciate your contributions to the playlist. Decline. Thank you for your $10 super sticker. Chris Pope or Chris Popple. Chris from Toronto is here. Fellow Deadhead. Love the show. Thank you, Chris. Cruelty Free Chapstick is here. Pro Fun Diddy. When I'm in a sober mood, I worry, work, and think. When I'm in a drunken mood, I argue, fight, and drink. But when my moods are over and my time has come to pass, I pray they bury me upside down so the world can kiss my ass. Well done. We do think in song lyrics here, so thank you. Val Sanchez for your super chat. On John O'Keefe's pants that he was wearing, there are 4 different male DNA. On his shoes, 5. On his shirts, 3. It is in the testimony, previous hearing. Very important. Yes, they need to focus on that more. We also do know, I think, that the samples were not not good enough to test, so that's why they weren't tested. But yeah, really, 3 unknown contributors, or at least 2 unknown male contributors to the blood stains on his jeans. Proctor and Buchanan, remember, they gave DNA, so they were ruled out. GV, thanks that you want to battle. Here's a war on the playlist. I do not think so, but I can't get into Spotify right now. Oh, it's working now? It was down this morning. Melissa Besford, thank you for tuning in from Australia, says, looking forward to spending the next few hours with you. I ordered one of your hoodies. My 7-year-old saw it and said, hey, is that from your friend Melanie on her show? Can you play her song? That's awesome. So many kids love rocking out to my theme song, and I love it. The merch shop is all 20% off today. I'm going to put the link in the chat again. The link is in the show notes, but I'm going to put it in the chat again so that you guys, if you want any merch, get it today. But make sure you hit the coupon at the top to get the 20% off if you need your, Cancun. There. Now it's pinned. Oh, I did it. Okay. Thank you. Thank you, Melissa. I'm glad you like it. And your son likes the song. Bewildered in Texas saw Bob Dylan at CU Folsom Field, 1976. Wow. Those are the days. Go Buffs. I have an emoji for that too. I'm a proud alum of the University of Colorado in Boulder. And I loved Boulder so much that I stayed in Colorado. I went to Denver for law school, but I lived in Boulder and commuted every single day because it was worth it. The rubber duck is here. The Sallyport DVR was what was empty. The detective file is different, correct? We don't know. He dropped and dragged it to a different folder. And so it's very unclear, Rubber Duck 77. If anybody in the chat can clarify for us what exactly is going on with that Sallyport video, because the expert went there and they said, no, it's not on there because it overwrites within 30 days. And so that's why we don't have any of the video. But then it turns out that it wasn't overwritten because this retired sergeant, DGM Pietro, had downloaded 3 days worth of footage of Karen Reed's Lexus, which the Commonwealth is saying is the murder weapon. They downloaded it and it's somewhere. So I'm not really quite sure. It is very, very, some people think it was done deliberately to destroy metadata. We don't really know where it sits right now. It's very unclear. There have been 10 or 12 different stories about where those videos are and if there's any metadata, whether it's still in the original system, whether the metadata has already been destroyed. We don't know. They keep changing their story. Patio says there's a state police car parked in Hank's driveway 24/7. Is that true? I don't know anything about that, Patio. Val says, I think show the taillight was intact and also DNA. Thank you, Val. Just a robe, Bev, your bias is showing, is here from Ireland. I'm late to Bev and Hank's lemonade stand. I've only joined in and I'm annoyed. Yes, we are all annoyed. We're still outraged. We have a we are outraged emoji as well. Metadata Head says, this is my first trial I've ever watched. And unfortunately, worry about our justice system. I loathe Breenan. My sis is Denver law enforcement and she's free Karen Reed. That's amazing. I'm, this is like getting thrown into the fire. If this is the first trial that you've ever watched, this is certainly a doozy. I will tell you that they don't all operate this way. This is wild and it's disturbing. And Karen Reed could be any one of us. And I think that is why, or just one of the many reasons why the world is so outraged about this, because John O'Keefe did not get hit by a car. And a car did not hit John O'Keefe.
Think about that. Okay.
And that's really how easy it is. And if he didn't get hit by a car, there's no crime. Karen Reed's not guilty of anything. There's no standalone DUI charge. They're back.
Put us back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Yeah,
Okay.
then you didn't turn over what you
I was able
intend
to see the
use.
video.
Super.
Okay.
Work.
All right, were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay,
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
okay,
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay.
Dude,
Can
where's my
Can we
gun?
address, is it something you need for your opening?
It's not.
It's
Okay, all right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay, so
Kevin Albert, who is Brian Albert's brother, Kevin Albert is with the Canton PD, got so drunk with Michael Proctor while they were on the job that he lost his gun and his badge. And he contacted Proctor the next day, like, dude, where's my gun? I was so hammered, like, I don't know where my gun is. And Proctor's like, I don't know. I found your badge, like, in my cup holder. And he's like, oh, cool. Could you drop it off at my my mailbox? And while this was going on, Kevin Albert got the whole summer off with pay, I think. And that'll be great if they call him as a witness. That'll be fantastic.
now is the only thing left the motion that Mr. Bradle's here for?
Welcome, Christine, as a VIP.
Okay.
Welcome, Christine.
All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So,
This is Tim Bradle. He is Aidan Carney's attorney. His name is Carney. I wish someone could pronounce it right. There is a motion to exclude Aidan Carney from the sequestration order because he is now on the witness list for the Commonwealth, and he's number one on the list because they have alphabetized it according to first name. We went over the papers yesterday in yesterday's stream. I have kindly timestamped it for you so you can go straight to the reading of that motion. But the argument is basically this. Aidan Carney, aka Turtle Boy, is a reporter. He has been reported pretty much exclusively on the Karen Reed case since the spring of 2023. To exclude him from being allowed to sit in the courtroom during this trial is to essentially cut off his income. And exceptions are made for reporters all the time. You made an exception for Gretchen Voss, the last trial, and so you should make an exception for Aidan Carney. So here's the arguments. Let's hear what Bradle has to say. I love watching Bradle argue. He's amazing. Let's go. Bring it.
Jim, you have that. All right, I probably have it here too. I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle.
Mr. Fredo, it
Mr.
said
Brennan,
Mr. Fredo.
You're asking for sequestration on
The
all the witnesses
Godfather.
other
The
than,
Godfather has entered the chat. They called him Mr. Fredo. You know, you know. And both sides agreed, they stipulated to let Gretchen Voss in for this trial. We read that agreement yesterday as well. Let's see if Brennan is going to fight to keep Aiden out. This is interesting because we haven't seen any papers from him. He didn't put anything in writing. There's no papers. So let's see if she even considers his argument that's not on paper.
Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aiden Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to
course
call
he
him
is.
in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls
Roboto.
the defendant to the stand,
The other is Roboto, it said.
strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradel.
All right, thank you very much,
Go
Your Honor.
Tim. Go Tim.
Judge,
It's
we
your
don't have
birthday.
an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Carney, who for the record is in the second row here today.
All right, can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness
Okay,
intimidation.
so just focus back on.
So the answer is yes. I'm sorry.
him
The answer
argue.
is yes, Judge.
Okay.
Lady Macbev.
So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor,
Didn't she just say Mr. Brennan? And then Bradel keeps arguing? Hold on a second.
So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan. And you
Oh,
said-
I'm sorry.
But that's okay. I don't want to hear about
Got
the
it.
witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Get ready for the faux
Your Honor, you have
indignation.
questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I
And
would, as a predicate, he would need to assert his fifth.
do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Oh, you're going to
Mr.
put him on the
Bradel, do you
stand so
wanna
he
do
can
that
take
now?
the fifth?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
You're going to make him get up on the
Okay.
stand right
Do you
now?
want to call him now and do that now, Mr.
Son of the world
Bradel?
and never look at Aiden. Look
Or
at his
not? Do
face.
you want to talk with your client and
Tell him what to say. Tell him
Sure.
how this works. This is
Why
ridiculous.
don't, you know what, I'll give you more than a minute, Mr. Bradel. Can the
Ridiculous.
staff work through lunch for a little bit?
Yes.
Everybody stay? All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
We're gonna
All
have a
rise for the court,
show, my
please.
friends. We're having a show. She's gonna make Aiden Carney get up on the stand, and she's gonna make Aiden Carney take the fifth because Hank wants him to. I gotta watch that again. We gotta watch that again. We're taking it back. So they both agreed that they could live by the same rules as the last trial, that if any of the 12 or 19 or however many people are alleging that he witness intimidated them, like Proctor Buchanan, because they're really afraid of Aiden Carney, Jen McCabe, Colin Albert, Brian Albert, anytime they're testifying, he can't come in the courtroom. That's what they did last time. And did she also say the minor witnesses, meaning the niece and the nephew? But now Bradel's assertion, Attorney Bradel's assertion that he intends to take the fifth, because here's why. When they did that whole motion in front of Sisitsky, Cosgrove said, well, you know, the grand jury, or there was a different motion, I think. Cosgrove said, he's the special prosecutor assigned to prosecute Aiden Carney. The grand jury failed to indict Karen Reed and Aiden Carney for witness collusion or conspiracy to commit witness intimidation before the first trial in April, I think, of 2024. However, they are continuing to investigate and they may bring charges still. So now Bradel's like, okay, well, now they're saying they may bring more charges against Karen and Aiden for conspiracy to commit witness intimidation, that they wanted these text messages to show consciousness of guilt on behalf of Karen Reed. And so therefore Bradel's like, okay, if you're telling us that you still want to try and get him on conspiracy charges, he's going to plead the fifth because he's not going to testify. This is wild. Hold on. My freeze game's on point. Look at her. Under her eye, everyone. Under her eye. Welcome to Gilead.
Hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no
It's right here in the
realistic
back row.
likelihood that we would call him. There's obviously
On the end.
procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
Why the
And
minors?
As a predicate, he would need to assert his fifth.
do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment
Wow.
privilege, he can assert it.
Wow.
Do
Look
you
at
want to call him
Meredith.
now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't
I'm-
you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Wow. This was all rehearsed by Brennan and Bev. Says Fiddlesticks good. They're taking a little break before they're going to make Aiden Carney get up on the stand and take the fifth. So Bradel's like got to talk to him in the hallway. Like, here's what's going to happen, and here's what you got to do, because he doesn't know what's going to. I don't know that he's ever been on the stand before. Maybe he has, but not in worldwide television. So I know he's going live tonight. So you guys aren't going to want to miss that show. Wow. No, it doesn't officially start the trial because the jury is not here. The jury has not been sworn. This is just something that she wants so that she can determine whether or not he's allowed to be in the courtroom. This is insane. I mean, you first time Karen Reed trial watchers, you were getting a taste of what is yet to come. Somebody said, I thought Gilead was bad. This is scarier. This is scarier. This is great. Aiden against Brennan. Let's go back to the chat because you guys have a lot of questions. Blow eating Brennan, David Reese said, didn't he initially oppose based on the defense not being allowed a rebuttal? Yes. About Garrett Wing. Yes. And then the defense said in their papers, what do you mean? We never said we were only calling him on rebuttal. We said we're calling him on our case in chief. Everyone remember to hit the like button. Fredo says so. Please do it. Thank you. We might have to close the chat out to get it done. My nurse Kel says, I want to see the image of people whom have had an arm cut up by a taillight. And I bet he hires his cousins or something. Should read them and show actual timelines this time. AJ sounds sick. Everyone on the defense team sounds sick. They've been working 24/7 for as long as they've all been in town, which is, they started jury selection 2 weeks ago. So they were here probably a few days before that. Who knows what's going around? Chloe Albert's Revenge says, Trooperino is so bad. That's Garino, for those of you who don't know. And finding text, if he actually found these, give that man his flowers. Let him read. Right, exactly. They don't need to call an actor in to act out the text messages. Nothing to see here. This is crazy. I never heard such a thing. It's a trial for someone's life, not a movie. Yeah, he wants to hire actors to come in, or somebody to come in, a male and a female, to read Karen Reed and John O'Keefe's text messages. And I nominate Will the Glairer and myself. We did it once on his show. It was great. Meredith is Aiden Carney's girlfriend. Somebody saw that fly by. Cruelty-free chapstick. Thanks again for another 20. Marcus Valerius Marshall, circa 40 to 140 AD. I could do without your face, Chloe, and without your neck and your hands and your limbs. And to save myself the trouble of mentioning the points in detail, I could do without you altogether. Coming in with the classic deep cuts, the deep cuts. Quotes from literature on top. We have Beta Higgy and now Beta Terra. Yes, we do. Paul Marcy. Sorry, Melanie. Her name is actually Rick Astley, and she's never going to give John up, never going to let him down. Talking about Tara in the gallery. That's well done. Somebody said, who's the guy on the left with the pen? His name is Carl Dougal. He is also, I think, Boston PD, right? And he was a friend of John O'Keefe's. And he was kicked out of the last trial for allegedly bumping into Karen Reed in the hallway on purpose. So usually it was his girlfriend who was there, but I don't see her there today. Or his wife. I think it's his wife, maybe. Somebody said, OMG, the glare is flying and missing this. Oh, maybe he's got Wi-Fi on his plane. Maybe he's watching. Will, if you're here, give us a sign. Show us proof of life, Will. Will, if you're on a good airline, that means you have Wi-Fi on the plane. You're probably maybe watching. And if you're cheating on my channel, I'm not going to be happy about it. Kimberly Worley says, I just hope they don't clip it to make it sound like something it's not. Yeah, that's why the defense is entitled to see these clips that they want to play of Karen before the prosecution plays it in their opening. And they watched it and they were fine with it. So no objection. LJ, all Hank is doing is shuffling his papers. He's not using his notes to speak. He wings his speech. He's got a lot of faux outrage, right? Thanks, LJ. Dirty Hanky's here and says Hank Breenan sucks. Thanks for your 10. God, my head is popping off. If you know, you know. Thanks for your 10. I predict the jurors are going to be turned off by rat-faced Breenan. I'm wondering how he's going to play in front of a jury. I don't know. Brand new Nana says, can you explain why a judge is all to decided whether or not to recuse themselves when a motion of recusal is made? That's the way they do it in Massachusetts. We saw it in another trial, I think. Chat, correct me if I'm wrong. Was it Sarah Boone who made a motion to recuse the judge when she was representing herself? No, wait, it was another. Was it Robert Tellis when he was representing himself in Nevada, in Las Vegas? I remember we watched another trial where a defendant made a motion to have the judge recuse, and it was heard in front of a different judge, which is really, I think, is the way that it should be. But not in Massachusetts. We're in Massachusetts, upside down, inside out, Narnia, Gilead. My nurse Cal, who's the officer-looking guy on the end with the pin? That is Carl Dougal. I just addressed that one. LJ Bev seems almost as equally afraid of Arca as Brennan. It seemed like she really, really, really wants to know what the feds were given, what the feds were told, what the feds have. Like she's on a mission from God or Marcy. I don't know. Leanne says she's an eye for Marcy. Welcome to Gilead. Is anybody caught up on are you caught up on Handmaid's Tale? I watched the latest episode last night. It's getting a little wacky. I think June's going a little off the deep end with her self-righteousness, but that's just me. Maybe we could talk about that another day. On top, AJ is now your daddy worldwide because he said what I said. That's funny. Chloe Albert's revenge. So he's afraid the defense is going to do what he would do. Yes, exactly. Rules for thee, but not for me. That's what Brennan says. And they've paid him $234K so far. So, and counting, he's still billing. LJ, over, under request. Hostlong for Hank to snap when Ark is on the stand. Yeah, we'll take that bet during trial. Louis Opperman from South Africa. pronounced Louis, Julie, and Floki song suggestion. It can happen to any one of us. Gareth Gates. I will take that under advisement. Thank you so very much, Louis. Or Louis. Pronounced Louis. Okay, it's Louis. I'm sorry. That's what you meant. Louis. Your name is pronounced Louis. All right. Louis Opperman. Julie and Floki song suggest it can happen to any one of us. Gareth Gates. Thank you. Sherry, Bev is so worried about who did exactly what with ARCA, but not so much when it comes to MSP and KMPD regarding evidence and chain of custody. 100%. Thanks for your super chat. Leanne says, I'm new to the to trial watching, and it's shocking how upside down the justice system is. Welcome, everybody. Welcome, Leanne. You're in for a bumpy ride. You might want to buckle up, but you're going to like it here because we have a lot of fun. The chat is the best. The mods are the best. We call the chat Snark Tank for a reason because they make me laugh all day long. Yeah, I won't. No spoilers on Handmaid's Tale. The new episode came out yesterday. I watched it last night. Mom for life. The story shouldn't change if that's what really happened. One story, trial 1, and now a different one in 2. Which is it, Brennan? Right. Creative Gal, thanks for your 10. His only tone of voice is whine, and hers is huffy and witchy. Auntie, so disappointed as a resident of Massachusetts. I think you're in good company. There's a lot of Massachusetts residents here, and that's crazy. Ms. Holmes is here, and she says, what's he screaming about? What new testimony? He's making up crap that isn't even there, trying to rouse Kanoni to get her upset at AJ. Yes, Ms. Holmes, because he's done it before, right? Here's what happens with children. I know because I have 5. If there's no ramifications for their behavior, the behavior continues. And so when baby Hank Brennan throws a tantrum, stomps his feet, does wham, wham, wham. There's never any ramifications for his behavior. In fact, his behavior has been working at her upset at AJ because she had grave concerns and her head was going to pop off. And, she had to take a time out. And then even though he was lying, called court off for the day during that hearing about grave concerns, it's worked for him in the past. So why wouldn't it work for him now, right? Thanks for your super chat. Arca don't lie, says Mom for Life. Thank you. Breenigan, what a snake. A woman's life is at stake. You win over. Truth. Lawyer. Thank you, Kat. Carrie Ann says, I'm working on my master's in criminology, and this case is breaking my brain. Thank you for covering this. So I'm not broken alone. Yeah, that's like part of this is like a support group, for everyone who knows that Karen Reed is being railroaded and that John O'Keefe did not hit by a car, because really that's how simple this is. Thank you, Carrie Ann, for being here. Josh says the opinion of the IA investigation isn't just a third party. It was a Commonwealth agency who was a member of the prosecution team under Brady. That's exactly what I was going to say, Josh. Thank you for taking the words right out of my mouth. And that's another song we could put on the list. You took the words right out of my mouth. Must have been while you were kissing me. Name that artist. Sweden is watching. Hello, Maria. And thanks, Josh, for your super chat. Is that Marlo or Mario? Marlo is here from Canada. Thanks for your super sticker. Jamie, thanks for becoming a member. We're just waiting there on a 10-minute break while Aiden Carney gets ready to take the stand. It's going to be fun. Cruelty-free chapstick. I heard, by the way, after people were saying my chapstick was not cruelty-free, Tanis Yannetti was in chat. Queen Tanis Yannetti, I don't know if you're here. Girl, shout out. Love you. Said that the best cruelty-free chapstick is called Bitch Sticks. STIX at the end. It is cruelty-free, vegan, and also all of their proceeds or profits go to victims of DV, victims/survivors of DV. So I'll allow it. They don't sell it on Amazon. I don't know where to get it, so I'm working on trying to get some. Gwenin, Lackey Lally, Backhanded Bev, More or Less Marcy, CPD, Enter a Crying Murder, Most Foul, All Billing Taxpayers, Questions Defense. Here's Commonwealth. Yeah. Hey, Corruption, thanks for your 5. Do you think you may come to Boston at any time for trial? It would be an honor to meet you. Hashtag Queen ML. If I do, it's going to be top secret. And I'm not going to tell you ahead of time like I did last time. I think last time I just told you guys to go watch a different stream and said I had something to do. And then I showed up in Dedham. And it's, listen, safety first, you guys. Safety first. You know how dangerous some of these people on the internet are. Not yous guys, but some other guys. Yeah, it's Meatloaf. You're right. Oh, Studio B says, Melanie, you're our emotional support cupcake. I'll allow it. Thank you. Chloe Albert's Revenge. Why does she always need to expect everything if she's going to consider it at the time? She's just like moving the goalpost all the time, every time. The only time, she's ruled from the bench like maybe twice. One time was when she chose not to recuse herself. The other time was when the Commonwealth was trying to get text messages between David Yannetti and Karen Reed, and Alessi was in the middle of his argument, and she's like, you know what, let me stop you there. And we all thought she was just going to be like her usual nasty, snarky self. And she was like, I don't need to hear anymore. You're not getting it. And Brendan didn't get it. Right? Thank you, Boiled Frog. Ozzy. Hi, Ozzy. What cat did Brennan Little just let out the bag? This was at 12:36. What time is it now? 1:04. I'm not really sure. Not really sure which you're talking about, Ozzy. But Ozzy Insider is here. She makes great videos. God, my head is popping. Brennan looks like Pee Wee Herman, can't get it up. You know, you're not the first person to say that. You are not the first, and you certainly won't be the last. Oh, is Derek Carney here? Yeah, he's blushing. We played your video. We played your video. We love it. It's the anthem. It is the anthem for Karen Reed, and I'll allow it. A lot of people subscribe to you. Indie Girl said she subscribed.
You are unmuted.
I'm unmuted. It's awesome. The AI that you did is... Aiden Carney's going to take the stand. Get ready. We're popping off.
All right. Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
You going to put a stop to the circus, Bev?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right. So you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right. Thank you.
I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation.
Yeah, make a record.
On behalf of Mr. Carney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection?
Oh,
for everybody hearing this?
There is. I would like Mr. Kearney to consider his Fifth.
I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to
don't cut.
sealed Tory and Chrissy.
Oh, so she's going to do it at sidebar. She's not going to make him take the stand in open court. Derek Carney is here and he's blushing because we like his song so much. You guys loved it. Like, did all you guys go over and subscribe to his channel? So she's putting a stop to the circus a little bit, kind of. But I thought she wasn't even going to let Brennan go up there. I thought it was just, she just wanted to see Bradel and Aiden, and she's going to read him a colloquy and say, do you understand you have the right to plead the Fifth? Do you intend to plead the Fifth? Are you going to plead the Fifth? And all recordings are off. And let's check out the gallery. No. No, Piper, no. Piper, no. Let's go back. Let's go back. And oops, before they did that, we'll freeze. We'll oop. All right, let's see who's here. Let's take attendance. Craig Bates on the end, man of the tiny desk. He's my favorite. He came on my channel. I think these two other younger people in the front, I think these are interns, perhaps. Law interns, not quite sure. They have at least 9 law school students that are working with the team around the clock. Mr. and Mrs. Reed in the front. Meredith, that's Aiden Carney's girlfriend in the back. Kelly Reed, Bill Reed's cousin, and that is Esty. And I think, I don't know who's next to Esty, but we're not really getting much more. Nathan Reed, that's who it is. Then they go to the fan. So we're just going to, and Bradel's going back. Okay, Bradel's always well-dressed. He's very well-dressed, impeccable. Sartorial splendor, as always.
All right. So, Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege. And I find that if he were called to testify, he would, in fact, invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order.
Wow.
Except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that
It's
it
a
for
win
today?
for Aiden
Judge, if I may,
Carney.
just for the record, maintain the same objection I had at the last trial. Don't need to make any
Oh,
further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay,
But just for the record, thank you.
okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them. Do you, all right, this looks like you all made some progress in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue,
Oh, okay.
if the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy and
And it is something that we've done.
right, understood. I would like to see what I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All rise for the court, please.
See you next Tuesday, Judge Cannoni. See you next Tuesday. We're going to recap. We are going to recap everything that happened today. Wow. What a day. We got all that done in what? They started maybe at 10:30, less than 3 hours. It is now 1:10. Welcome. Welcome, prosecute. All right. Well, here's how the day started off. Let's see if I can do a recap for you because my notes are barely readable. But there were a number of outstanding motions today. The jury was finally selected yesterday after 10 long days of jury selection. They went through something like 561 potential jurors altogether. And they did pick 18 jurors who will be sitting on the Karen Reed jury, 9 women, and 9 men. The first motion that they heard today, that they orally argued, was the motion to compel forensically sound copies of the Sallyport video with the metadata. And did she ever rule on that? Because I don't think so. Brennan said, well, we invited them to come and look at the system. And he told them there was nothing on the system. And so he seems to think it's okay that they can just get the drag and drop file with no metadata. And he is totally opposed to them making a copy of the entire detective file because there is other stuff on there that they would not be privy to. And so she did not rule on that, but we know that Judge Cannoni does not seem to think that metadata is important. We also know, because there are many videos out there on the World Wide Web, that many of the video that they did turn over looks like it was altered. There are ghosts appearing in and out of the frame. The inverted video of the Sallyport has skipping and pieces missing and apparitions, and it's insane. But, in Judge Cannoni's courtroom, we never know what's going to happen. And she didn't even rule on that. In fact, I think Ms. Little was arguing that one. And she said, in fact, we just got a new report from retired Sergeant Detective D.G. Ampietro on February 27th of 2025. And so there's missing time. There's all kinds of things missing. And she didn't rule on that one. Nope. Second motion to be heard was about the view or the field trip. The jury is going to go to 34 Fairview. The judge has said that Karen Reed can go, but there was a big problem, apparently, according to the judge, about how Karen Reed would get there because she can't go on the bus with the jury. And so Alan Jackson was like, okay, we'll just take her in a different car. And she said, well, you all can't go in a different car. You can take her. One attorney can take her in a car that will follow the bus, and the Lexus will be at the site view. That was in question because that has never been ruled on. Next, there was a motion about Dr. Welcher's, I think, PowerPoint presentation, and the attorneys agreed that they were going to redact a part of his PowerPoint presentation. I think his PowerPoint presentation was something like 150 slides. Does anybody know? Welcher is their accident reconstructionist, the Commonwealth's accident reconstructionist. You didn't miss Aiden. She didn't make him get on the stand and testify. She called him to sidebar, and she found it sufficient that he was going to. But let me get to that because I'm in order right now. The next motion that we heard was about Garrett Wing. Garrett Wing, the dog bite expert that I had on my show all the way back in February of 2024 or January of 2024, right after Jennifer Coffendorfer tried to make me look like a fool. 2 times I appeared with her against her on court TV when I said it clearly looked to me that the injuries to John O'Keefe's arm came from an animal attack of some kind. So Team Brittany, one of my amazing mods, pointed out Garrett Wing's YouTube channel to me. He's got over 2 million subscribers. He is the guy who had been teaching for decades canine dogs to bite, to take down perps. And he's amazing. I have a whole show on it. Many of you have watched it. The defense decided to call him now as an expert witness. And so Hank Brennan was very outraged about it because he said it's too late to do any Daubert or Daubert Lanigan hearing, and that he says that Garrett Wing is not qualified and that he's never testified before and that he has no methodology about pattern recognition. And Alessi just got up and he basically laughed the whole thing off. He's like, really? James Crosby's not even a doctor. And quite frankly, Your Honor, we didn't realize that we were going to need to call an expert like Garrett Wing because never in a million years, I'm summarizing here in what he said in my dreams, never in a million years would we ever expect that you would allow James Crosby to testify because he's basically got a degree in something that no one's ever heard of. And he's absolutely 100% not a medical doctor. And in any event, Garrett Wing, Lieutenant Wing, his methodology is clearly set forth in his report in about 1 million places. And it's not going to be in our rebuttal case. It's definitely going to be on our case in chief. And then the judge said, okay, well, what about, this whole thing about the bites being Chloe's bites? And then, of course, Brennan says something that I can't really read, but basically he said, Alessi is arguing that it's junk science, this odontology. And then Brennan said, well, we're just going to have Crosby testify that Chloe has to be excluded, that it's not included. Brian Miller, why are you, okay, you don't need to redirect people to another stream, but thank you so much for letting us know that. You guys can watch that later if you want to. I'm trying to wrap up and do a summary. Thank you so very much. We just want to exclude Chloe as the culprit, not say that she absolutely did do it, but that there's no way that Chloe did bite John O'Keefe's arm. And the judge said, well, you're going to have an uphill battle. And then Alessi got up and pulled out some National Association of Science study about methodology. And I don't know, did she even rule on that one? I don't think so. Then there was a motion to substitute one Bodie Labs witness for another, and they agreed to that. So the defense had no opposition, and so that's allowed. I think it was Tess Chart who testified last time about DNA, and she's the one who did all the DNA comparisons. And because of medical reasons, she can't be there. I didn't know if she would allow that, but the defense agreed to it, so they're like, whatever, no big what. And then there was they each made motions about notice. They want Commonwealth wants notice of any of chalks or exhibits that the defense is going to use in their opening, and the Commonwealth wants notice of anything. The defense wants notice of any of the Karen statements that they intend to use in their opening, and they both said that they will provide them. The judge went back and listened to a clip and saw a video, and defense had no objection to that statement of Karen being used in their opening. So they agreed to, they're fine with it. And Karen Reed said yesterday outside of court, she said, I don't care what they use. Everything that I've said to the media or in interviews, I would say again. Come at me. Then there was another motion, 638, which I have to look at in greater detail. There was I didn't have that motion in front of me when they were arguing it. But they did agree on a couple of things, and I don't really know. Then they got into the ARCA thing, and that is when Brennan got up there with his faux outrage. He had so much faux outrage. It was wild to see. Trial by ambush, all of this BS. They haven't given us anything. And there was a whole lot of arguing about that. And the issue is that The defense doesn't have the stuff that ARCA was given to do their initial analysis, their initial accident reconstruction. So how can they possibly turn it over to the prosecution? And we've been screaming into a closet about this for a very long time. And also, any correspondence the FBI had with ARCA is not discoverable. The feds are not going to give that up. It's all privilege, so you can't have it. And then, he's whined and screamed a little bit more. He needs a binky. I think he needs a binky. Brennan, maybe we need a binky emoji for him. And he said, that he thinks that the ARCA witnesses have some sort of like nefarious relationship with the defense. Not exactly. I'm just summarizing. And, the deadlines have passed and they can't give us anything. And so I don't really care if they testify, but blah, 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 blah. And then Alan Jackson got up and gave his usual smooth as butter response to that. He said they filed their certificate of compliance and they're still turning over discovery, Your Honor. Like as of yesterday, they served us a notice of discovery number 64, which we went over yesterday. And then he said on March 26th of 2025 was the first time that the DOJ gave permission for the defense to really hire ARCA. And he said the Commonwealth could have hired him too. But of course, they didn't. And then Brennan got up and whined a little bit more. And then Alan Jackson said, why doesn't he just call it like it is? He's trying to prevent ARCA from testifying. And we loved it. We played it over twice. And I don't think she made a decision on that, did she? No, she just didn't. She didn't. Then, he whined about his ambush being outraged, faux outrage, blah, blah, blah. And then AJ got up and called him out on his feigned indignation. His feigned indignation, which was great. It was fantastic. Then there was some discussion about the internal affairs investigations. And then they actually took a little break and then they agreed that the internal investigations, the Commonwealth agreed, Brennan agreed, the sustained findings as to Proctor, Buchanan, and Tully were admissible. He would allow them, that they were still disputing Kevin Albert's, dude, where's my gun? Findings. Then we had a whole mishigas about Aiden Carney pleading the fifth. And then we thought the judge was going to make him get up and plead the fifth because that's what Brennan said. I want him here. He's here. He's in the back row. He should get up and plead the fifth if he's not going to testify, because otherwise he has to sit out for the whole entire trial. And Bradel got up and he made a great argument. And the judge took it sidebar, gave him a colloquy, and said, I am satisfied that he will take the fifth if you call him. And so therefore, I am exempting him from the sequestration order. He's allowed to sit in the courtroom for the entire trial, except for when any of the witnesses who have pending charges against him for witness intimidation, when they testify, he can't be in the courtroom. And that's the same thing that happened last time. And I think he might have been a little bit nervous that he was not going to be allowed in. And so he must be very, very happy. Melanie Little's Magic 8 Ball is here. Thank you. I went and looked. It was Officer John O'Keefe's left shoe that was recovered. I can assure you he did not kick the taillight with his left leg. He was right-handed. I hope Hank sticks with the Wendy theory. Yeah, that was wild. If you didn't watch yesterday's show, it's timestamped for you. You can check out the new theory that was tweeted about, that Wendy Murphy tweeted and says, this is the story that Hank Brennan is going to tell, and the Commonwealth can't refute. And it's that kick in the taillight. Ms. Holmes 66 says, Hank trying to rile Bev up against the defense. I think so. Texas Tan Girl says, my 91-year-old lovely mom is watching the trial with you. She keeps on about Karen is framed. That's amazing. Amazing. Happy. Thank you to your mom for watching and also for you watching. Texas Tan Girl from Texas. So hi to your mom. Shout out to your mom. Athena Esquire says, Hank proves every day he doesn't fully grasp the case. I believe he will alienate the jury with his whining objections and snarky demeanor. I don't know. He turns me off, but that's just me. Thank you, Athena, for your super chat. Cruelty-free chapstick. Been very unwell in recent months. Got to take a break. I'm sorry. I'm very sorry if you got to take a break, but do whatever you need to do to take care of yourself. Hoss dare you. Thanks for the 20. Says, born in the Springs, raised in Denver, best concert resort at Red Rocks. Yeah, agreed. Rocky Mountain High. Thank you, Kansas, for Karen. Thank you. Susan here. Aiden's grinning from ear to ear. He wants this. Watch out, Hank. You just walked into a trap. Yeah, and maybe the judge sensed that, and that's why she did it all at sidebar. Maybe. Julie Jensen gifted a membership. Thank you, Julie. Double Trouble 247. Wait until Spanky meets Aiden. Have they never met? I don't know. Tracy Aiden's loose cannon on a good day. Why would they call him? They're not going to call him. They never had any intention of calling him. It was all for show. It was all for media. It was all to get him at the top of the witness list. Charles says, I think Chairman Mal Canoni is a smoker. She always wants a smoke break. I don't know. I have no idea. I know Lally is because I just know that because people would see him smoking outside the courthouse like a pack a day or a pack at a time. Christy doesn't worry that readers would give inflections and be snarky. Yeah, I know. Same. As is Alan Jackson, which is why he wants to do more research. Edward says Barinan's argument is that the Commonwealth needs to change its theory based on what the defense says, but this is not how that works. That's right. Joyce says, can Proctor plead the fifth? Well, he hasn't been charged with anything, but if he thinks that he would incriminate himself criminally, he can plead it. And I think in Massachusetts, it's on a question-by-question basis. He can, but will he? He might be willing to throw everyone under the bus because they threw him under the bus, as the judge did in her order. So it'll remain to be seen. Derek is here. Oh, Derek Carney is here. We showed your video at the beginning. We love your song. So if you guys didn't see Derek Carney's anthem to Karen at the beginning with some really wild AI, go back and rewind it and watch it later. Thanks so much for taking the time to watch my video and listen to my song. I really appreciate it. I hope it helps Karen and all this nonsense. Love you, Melanie. Love you too, Derek. Thank you. Thanks for your 20. Happy to do it. Everyone go like Derek's video and subscribe to his channel. Technical out. I've also linked it in the video description below the video. Technical out says, hello, y'all. It's Piney Woods. I miss y'all so much. Still feeling a little loopy. Bev's gotten worse. This is scary, and I'm stuck in bed for 6 more weeks. Well, we're wishing you, sending you all the healing vibes and hoping that you get better real soon. But we're happy to keep you company, whether you're loopy or not. And, you know, it's even more fun when you're loopy because maybe you laugh more. Josh says, how does Brennan know anything in Aiden's cases? Well, he tried to, you know, he actually, when he made that motion to get the text messages, he actually put in his papers, you know, I really don't need to make a motion because this file, the Commonwealth versus Aiden Carney, is within the possession of the Commonwealth. And so really I could just go into that file and take whatever I want, but I'm going to make a motion like a good boy. It was gross. So you decide. Prosecute became a member. Welcome. And Santini's been here for 6 months. Thank you. Marlo is here from Canada. Does Bev not rule from the bench so she can first check with Meatball? We don't know. Can defense ask for communications between Bev and him? I'm physically sick. Well, they did get in discovery a lot of Michael Marcy's communications. He's the district attorney for Norfolk County because he used his own private email server to email a whole bunch of judges. And so those communications did become discoverable, and we just don't know what's in them yet, Marlo. So stay tuned. This is going to be a wicked good trial. You're not going to want to miss. Hank's High School Swirlies. Thanks so much. From another mom of 5 with twin teen daughters. Oh, yes. You're doing the Lord's work, too. Thanks for watching from Canada and for your super chat. And on top, you're always so on top of the super stickers. I appreciate you. Suzanne says, thanks to the mods in the chat today. Appreciate it. Thank you, Suzanne. Nina is here. What emails with ARCA is Hank talking about? Any emails between the feds and ARCA, or any emails which he's not entitled to, or any emails between the defense team and ARCA, like scheduling emails or whatever. I don't even think he knows what he's talking about, Nina. I don't even think he knows, really. Chloe, they made me do it, says, Kwai me a wiva, poor little Hanky Blennon. Time for a diaper change. Use plenty of powder spanky. You're gonna get a rash. Well, yeah, it's wild and it's happening. Hank is no Billy Zane. That's for damn sure. You know it. Let's see if we have any other. Karen Davis is here, and she is sending a Venmo and just says, thank you. Thank you, Karen. Just a reminder, the link to the merch is pinned. I think it's pinned in the chat somewhere. It is 20% off. Make sure you click the coupon at the top of the page if you want any merch. And thank you to Jim for your Venmo. And Colleen, who says, tuning in for the first time today, got to see AJ right away. I love this team and I love the way you educate me. Well, it is my pleasure. Thank you so much for your Venmo. You're very sweet. Andrea, thanks for sending me coffee money through Venmo. That is amazing. You are amazing. Each and every one of you. I love you all with all of my heart. All right. And any more thoughts, questions, comments, concerns? We're going to be back here. I don't know if there's any new filings today, but we're coming back Tuesday is opening statements, but there's going to be a whole lot of more stuff for us to talk about before that. So you're going to want to make sure that you hit the subscribe button because it's free. You're going to want to make sure that you hit the like button because it helps the girl out. Share the stream out, get the world talking about this because so many more people are becoming interested in this trial the second time around. With good reason, because Karen Reed is being railroaded. John O'Keefe was not hit by a car. 13 flags. Can the defense cross Trooper Paul on his previous findings if the Commonwealth changes their story? Yes, they can. Anything he's testified to in the first trial is fair game. Could they question other witnesses about previous statements? Yes. Previous statements, previous testimony. It's all fair game. Thank you for your super chat. Canoni's Baloney Jadzia says, is grave concerns a reminder to Bev that Marcy is watching? Just speculating. Could be. They have hand signals. They've got word signals. They've got safe words. All of it. All of it. Squirrel. How is Bodies by Drowning Pool not on the list? I don't know. I don't know that song. You just turned me on to something that I didn't know about. Ginger Taylor, love your coverage. Thanks for all you do. Oh, thank you. Thank you for your 20. All right, my friends, it's only been 3.5 hours this morning, which is relatively light for us. And so Zoe says, did you hear Judge call the court reporter Chrissy when directing no recordings of Sideboard with Turtle Boy? No, her name is Chrissy. All right, so now we know her name. I didn't hear it, but I'll allow it. I'll allow it. Nothing to see here. This trial should be off the equator. Did defense ask for all Commonwealth witnesses' phones up to now? No, they're not allowed to do that. They're not allowed to do that. I'm sure there are tons of texts now. There are only certain ones that are discoverable. Rule 17, third-party motion rules in Massachusetts are very, very strict. And so, no, they're not allowed to have everybody's text messages on the witness list. Only some. Thank you for thanking me for sharing my day with you. Thank you to the moderators for keeping it classy today. You are amazing. Thanks to my members, channel members, replay viewers, and viewers. Everyone would please hit the like button and make sure, all the things that YouTube likes are done. Until I see you again, my friends, stay cool, stay kind, stay classy, stay calm. I'll be back real soon. Peace, everyone. Have a great day.